Madam Speaker, therefore, I wish to indicate that I beg to move that a bill shortly entitled the Bail Amendment Act 2023 be read a third time.
A second time. It has
Beg
been
your pardon,
moved
sorry.
and seconded that a bill shortly entitled Bail Amendment Act 2023 be now read a second time. Those in favor say aye. Aye. Those against say no. The ayes have it. I call upon the clerk to read the bill a second time.
An act to amend the Bail Act to permit a surety to apply to the High Court for release of obligations under a recognizance.
Under Rule 45 of the House of Assembly Rules of Procedure 2021, the bill now stands referred to a committee of the whole Assembly to be considered clause by clause. Assembly in committee.
Clauses 1 to 4.
I put the question that clauses 1 to 4 do stand part of the bill. Those in favor?
Aye.
Those against? The ayes have it.
The title and the enacting clause.
I put the question that
Just forgive me, Madam Chairperson. I wish to propose that in the title, the year be altered or amended to represent Bail Amendment Act 2024 instead of 2023. Thank you.
So I put the question that the Bail Amendment Act and the title be amended as bail. Oh, I'm sorry. I do need somebody to second. Sorry.
I second, Madam Chair.
Thank you. It has been moved and seconded that the title Bail Amendment Act 2023 be amended to read Bail Amendment Act 2024. Those in favor? Aye. Those against? The ayes have it. I put the question that the title and the enacting clause do stand part of the bill. Those in favor? Aye. Those against? The ayes have it. The Assembly will now resume its sitting. Your report?
Madam Speaker, I beg to report that the bill shortly entitled Bill for Bail Amendment Act 2024 has gone through the committee stage with amendment and is ready for third reading.
Bail Amendment Act 2024, third reading.
I'll be exercised today. Madam Speaker, I beg to move that a bill shortly entitled the Bail Amendment Act 2024 be read as a third time and passed.
Madam Speaker, I raise a second.
It has been moved and seconded that a bill shortly entitled A Bill for Bail Amendment Act 2024 be now read a third time and passed. Those in favor? Aye. Those against? The ayes have it. I call upon the clerk to read the bill a third time.
An act to amend the Bail Act to permit a surety to apply to the High Court for release from obligations under a recognizance.
Bill read a third time and passed.
A bill for Electronic Evidence Act 2023, second reading.
Members recognized?
Madam Speaker, I beg to move that a bill shortly entitled Bill for Electronic Evidence Act 2023 be read a second time.
Madam Speaker, I rise to second.
Well, the Premier did tell me it's going to be a long batting order. Madam Speaker, honorable members, the objects and reasons for this legislative initiative can be shortly stated in the following manner. The bill provides for the admissibility of electronic records. The bill makes provision for the legal recognition of electronic records and to facilitate the admission of such records into legal proceedings and other related proceedings. The main objectives of the bill are to establish general admissibility of electronic evidence, set forth the criteria which lead to the presumption of the integrity of computers and electronic records, address relevant burden of proof, regulate admissibility of electronic signatures, and contemplate recognition of electronic records originated or located in other countries. Moreover, the bill seeks to amend authentication and best evidence legal rules. The bill consists of 3 parts. Part 1 provides for the definitional provision that is common to all enactments of this kind and others. Part 2 amends authentication and best evidence rules, establishes the principle of non-discrimination against electronic records, regulates application of the best evidence rule, defines criteria for presumption of the integrity of computers and electronic records, allocates burden of proof, determines issuance of guidance on compliance with technical standards and with security procedures, acknowledges agreement on admissibility of electronic evidence in judicial proceedings, recognizes electronic signatures as evidence, and addresses alternative techniques, it should be alternative techniques and procedures for the production of electronic evidence. Part 3. Part 3 establishes general provisions contemplating admissibility of electronic records from other countries, recognition of foreign electronic records from other countries, recognition of foreign electronic signatures, interpretation in accordance with internationally accepted principles, and possible regulations aligned with international best practices and standards. This part also provides for the citation and commencement clauses. Also under Part 3, it would be proposed as an incidental function of the protections of electronic data stored in certain peculiar devices, which by their very makeup were designed to protect in a very firm way private information, how and in what circumstances and under what conditions intrusion onto those private material or data will be permitted judicially. Having said that, I think I should just say before I take my seat in relation to the objects which I have and reasons for the proposed enactment. There is another enactment on the books which may recommend some confusion in the minds of persons looking at this proposal at a glance. And that enactment, I think, is the Electronic Transactions Now, implicit in its short title is the remit or the coverage, the reach of that enactment. They're supposed to modernize the law so that transactions conducted by electronic means, the forging of contracts, by emails and that sort of thing, will be covered by that enactment. This goes a little further, so that although there is overlap, there is no repeal or amendment of the existing Electronic Transactions Act. Overlap does not mean a repeal. This is much broader in that this tells you what is electronic evidence, how it is going to be admitted in court in proof of matters. The other one does not go so far. The proposal is timely, I think, in bringing our evidence laws up to date with emerging technology and technological techniques, so that there would be a seamless undertaking in the courts in terms of the proceedings and the adjudication of disputes by initiatives such as this one. But mindful of the susceptibility in the minds of some that there is some sort of conflict with the existing Electronic Transaction Act, we have made it clear in the conflict provision, which is before honorable members, which reads, in the event of any inconsistency, and there will not be, but out of the abundance of caution, in the event of any inconsistency between this act and any relevant legislation, this act prevails to the extent of the inconsistency. So in relation to what is electronic evidence and how it is capable of proof and how it assists in proceedings, will be the statute, the go-to statute for such matters and for that reference. Importantly, honorable members, it will be readily observed that this proposed enactment is not merely procedural. It does not simply set out a procedure for collecting and submitting or proving electronic transaction, electronic signature, electronic documentation. It goes a little further. It makes certain types of electronic or electronically generated documentation evidence itself. It also speaks to data and the protection of data, which is important because that is a function of the constitutional right to privacy. Now, admittedly, all rights, save a few, that is, to torture and slavery, are not absolute, so that there are permissible exceptions. But the unique nature of electronically stored information and the preponderance of devices that hold these kinds of data, cell phone, smart devices, tablets, computer systems, information systems. The data itself stored on that by means of this enactment, one, is your private property. Two, under the conditions set here, can become evidential for particular purposes, not necessarily criminal purposes or criminal proceedings, but there are other purposes. And because it does that, there is need for clarity in relation to the safeguard of that constitutional right to privacy from which it springs. And so therefore, there is a proposal of the substituted section or clause at this stage, clause 18, which talks and addresses specifically, a situation where information stored on these devices and systems are required to be examined and perhaps extracted for the purposes of criminal proceedings. Having regard to the sanctity of that privacy right and its constitutional pedigree, it was necessary to make clear, beyond any kind of doubt, how protected this constitutional guarantee is in relation to this information stored on emerging technology. And so, the substituted clause 18, provides, and it would be useful for me to detail it because of its breadth and the deliberate scrutiny that it would require. Interrogation and extraction of data from electronic devices and information systems by judicial warrant only. Clause 18, sub 1. Upon evidence shown by a police officer not below the rank of inspector that stored data would be relevant for the purposes of an investigation or the prosecution of an offense, police officer may apply to a judge in chambers. And I will shortly explain the formulation and why a judge in chambers. For the issue of a warrant to enter any premises to access, search and seize that data, or to interrogate and extract data stored on an electronic device or information system seized pursuant to an earlier warrant or a warrant issued under any other act. Sub 2. A judge may issue a warrant under this section only if satisfied that there are reasonable and probable grounds established upon oath to believe that an offense has been committed and that there is evidence to be found in such electronic device or information system relevant to the commission of the offense. Now, this proposal is a statutory affirmation of existing jurisprudence coming out of the courts, superior courts. Let me say that again. What I just read in sub 1 and 2 proposes a statutory affirmation of existing jurisprudence, constitutional jurisprudence, emerging from our superior courts. Why judicial warrant by the High Court judge and not by the magistrate? Under the Constitution, the only court that is charged with the protection and enforcement of fundamental rights that are guaranteed in the Constitution is the High Court. Privacy rights are an entrenched and jealously protected constitutional guarantee. It is not that we are suggesting that magistrates don't know the law. It is a question of the pedigree of the right engaged here and the anxious scrutiny that must be brought to bear by the adjudicating officer over a request to intrude on such devices. Because I'd like to make it clear here, it is not presently on the jurisprudence from courts, it is not the law that because you have a warrant to search premises and take perhaps certain receptacles and other things, computers, watches, phones, cabinets, a safe, and so on. That by virtue of the authority of that warrant to search and pick up those things, in the case of electronic devices, you thereby and at the same time have the authority to go into them. That is not the law. Actually, you have to get a separate warrant from a high court judge to intrude on electronic devices, as I said earlier, because of the nature of those devices: phone, computer, tablets, etc. This recognizes this and makes it pretty clear that that must always be undertaken in relation to those devices. Sub 3, in the execution of a warrant under subsection 1, the powers of the police officer shall include the power to access, inspect, check the operation of an electronic device or information system. B, use or cause to be used an electronic system to search any data contained in or available to the electronic device. Certainly that is after the warrant is granted. Sub-clause 2 is the minimum standard upon which the court can be moved to grant the warrant. And unless that standard is met, can't be going into people thing. C, access any information, code, or technology which has the capability of transforming or unscrambling encrypted data contained or available to an electronic device or information system into readable and comprehensible format or text for the purposes of investigating any offense under this Act, or in any other offense which is disclosed in the course of the lawful exercise of the powers under this section. As my distinguished friend the Minister indicated earlier, these are useful tools indeed for the police in investigating crime, particularly the search in the kinds of crimes that we have been seeing. However, honorable members, we must remind ourselves, in as much as we are responding to social phenomena, we must always bear in mind that we have to balance, and we must strike that balance first here, the community interest as against the individual interest. This achieves striking that balance. D, require a person in possession of the decryption information to grant the police officer access to such decryption information necessary to decrypt data required for the purpose of investigating the offense. E, seize or secure any electronic device or information system. 4, a person shall not knowingly or without lawful excuse or justification obstruct the police in the exercise of the powers under this section or fail to comply with a request made under this section for access to information. And sub 5 provides that that contravention of subsection 4, that is to say an obstruction in relation to the examination under warrant granted by a judge of that information, would be a summary offense. Sub 6 provides definition of the matters referred to in the sub-paragraphs of the sections preceding, namely, decryption information means information or technology that enables a person to readily transform or unscramble encrypted data from its unreadable and incomprehensible format to its plain text version. Electronic device means a device that enables access to or use of an electronic communication service, remote computing service, or location information service, or includes personal computer, cell phone, smartphone, telephone, mobile device, wireless device, and tablet. Encrypted data means data which has been transformed or scrambled from its plain text version to an unreadable and incomprehensible format, regardless of the technique utilized for transformation or scrambling, and irrespective of the medium in which such data occurs or can be found for the purposes of protecting the content of such data. Privacy again. And plain text version means original data before it has been transformed or scrambled to an unreadable and incomprehensible format. So that, in a mouthful of English, is the object of the privacy protection provision, the substituted clause 18. With that being said, Madam Speaker, I wish wholeheartedly to commend this bill to the whole House.
Thank you, Honourable Member. I now invite debate on the merits and principles of the Bill for Electronic Evidence Act 2023. Floor is open for contribution. The Honourable Member for Valley South is recognized.
Madam Speaker, my contribution in relation to the Electronic Evidence Act will be very short, given the Honorable Attorney General's lengthy explanation and exploration of the various provisions under this piece of legislation. What I would like to place my public comment in relation to, Madam Speaker, is in relation to the inclusion in the statute provisions to ensure the technical assessment of electronic material and evidence being adduced in a court case. Speaking very directly, Madam Speaker, to the reality of the times we live in relation to digital manipulation and the use of corrupted material and electronic evidence. I believe that this piece of legislation, Madam Speaker, strikes the right balance between the protection of privacy of individuals, as we know that cell phones, laptops, and iPads, Samsung pads and tablets have become an extension to our everyday lives. And while it is important for us to be able to have access to these pieces of electronic equipment, it is equally important that we protect individual citizens' rights to privacy. And the legislation before us, Madam Speaker, speaks directly to the framework for data protection and the requirements, which are no mean feat, to ensure that that is a reality in Anguilla's case. And so, Madam Speaker, I wish to commend both the Attorney General's chambers and its draftspersons in moving to bring Anguilla along with the rest of the global world in relation to our electronic evidence protection. Thank you very much.
Thank you, Honourable Member. The Honourable Member for Valley North is recognized. It is.
I just would like to put on record, Madam Speaker, that I am in support generally of the Electronic Evidence Act. I've had an opportunity to review it. I do note, though, Madam Speaker, that if I'm not mistaken, that this act would have gone out to public consultation previously. However, this morning, I was furnished with the committee stage amendments, which are about a page and a half, and in my opinion are quite significant amendments. So I had a couple of general questions, Madam Speaker. One, what would have prompted these amendments and why were they not included prior to, and have they gone out for any sort of stakeholder consultation up to now? Because I know the initial act before the amendments did go out to some general consultation. I also note Also, Madam Speaker, that in Section 5, there is reference to actual punishment or imprisonment. So there is some level of, I guess, for lack of a better word, there's some criminal attachment to it, whereas I think, from my understanding, electronic evidence is supposed to look at evidence being permissible in courts, in legal proceedings, or being admissible, So those are just some general comments that I will hope to go through in a little more detail during the committee stages, Madam Speaker, as it relates to this. But I would like to say generally that I do support the Electronic Evidence Act, and I think it is important to bring all of our acts up to standard with, other regional and international counterparts. Thank you, Madam Speaker.
Thank you, Honourable Member. Are there any other contributions? The Honourable Member for Sandy Hill is recognized.
Good morning, Madam Speaker. Good morning to members of this honorable House and to those persons who are listening and viewing. Madam Speaker, I rise in relation to the Electronic Evidence Act that is currently before us. And I have to first say, Madam Speaker, that I'm happy to see that this act is now before the House. And it is indeed a case of law catching up with reality. And so we all would have had cell phones for many, many years. We all have access to emails, to online data, etc. And so this Electronic Evidence Act now puts in place provisions for the court to be able to allow these documents and evidence to be entered into the court. Madam Speaker, I do raise a concern in relation to the amendment that the member for Valley North would have raised that is currently before the House. And I heard the Honorable Attorney General make reference to it. The Section 18 of the existing bill, the Electronic Evidence Bill, is in relation to conflict. And it says, in the event of an inconsistency between this act and any relevant legislation, this act prevails to the extent of the inconsistency. And I would suggest, Madam Speaker, that whereas the amendment proposes to remove this provision, that I think that this provision in relation to conflict ought to remain, and perhaps there ought to be an insertion instead of a removal. The other matter, which is of more of a concern to me, Madam Speaker, is in relation to the replacement by a new Section 18. And that has to do with the interrogation and extraction of data from electronic devices and information systems by judicial warrant only. Now, the Evidence Act, and in fact, Madam Speaker, we have in front of us the Evidence Act that is going to replace what is currently on our books. And this is the Electronic Evidence Act. And both acts are actually making provision for documents and other types of evidence, such as hearsay evidence, etc., be admissible before the court. And in order for those items to be admissible before the court, they have to be grounded in the law in terms of the admissibility and following the steps for it to be utilized by the court and by the parties proposing to present the evidence before the court. But, Madam Speaker, the Electronic Evidence Act and the Evidence Act are not penal laws. When I say that, they are actually guides to allow the admissibility, and to use the words of the Honorable Attorney General, is the legal recognition of electronic records and admission into proceedings. Legal recognition of electronic records and admission into proceedings. It is not penal, Madam Speaker, where a party may be found to be criminally liable if you contravene any of these provisions. It is simply setting out the admissibility of electronic evidence to be brought before the court. But the insertion of the new paragraph 18 is not on the same footing as the rest of the provisions of the Electronic Evidence Act. And when I say that, the last paragraph 5 of the proposed Section 18 says, a person who contravenes subsection 4 commits a summary offense and is liable on summary conviction to a fine not exceeding $5,000 or to a term of imprisonment not exceeding 1 year or to both. So this provision actually inserts an offense into the Evidence Act, and that ought not to be the case, Madam Speaker. In fact, a provision like this, where it refers to the ability of persons being summary liable, should properly be before the criminal code or in the criminal code and not in the Evidence Act. And so, Madam Speaker, I would strongly recommend and suggest that it may be that the heading is incorrect in the summary stage, the committee stage amendments, where it says a bill for Electronic Evidence Act 2023. It may be that the insertion is actually intended to be in the criminal code. But to insert such a provision with penal provisions where persons may be liable on summary conviction to appear before the court, to place such a provision in the Electronic Evidence Act, I think is contrary to the intent of the Act itself, as well as to the objects and reasons that are set out in this Act. And so, Madam Speaker, with the exception of the proposed the Electronic Evidence Act amendment, which is to come during the summary stage, I would support the Electronic Evidence Act, but I would strongly request that this amendment be removed from the agenda and properly placed under the criminal code. Thank you, Madam Speaker.
Thank you, Honorable Member. Are there any other contributions? If there are no other contributions, I invite the mover to respond, please.
Madam Speaker, I thank honorable members for their contributions, inclusive of the concerns raised. I do confess, and I do not do so tongue-in-cheek, that I am slightly staggered. What was introduced and explained in relation to the substituted Section 18 is a safeguard in line with an entrenched constitutional right to privacy, so that it is, when it is passed, not legally possible merely for a police officer or for the police to gather electronic devices where private data is stored pursuant to a general warrant and go into them. It would be required under this to get a further warrant from a high court judge establishing a certain minimum standard to protect privacy rights while balancing the interests of the community, the police to carry out and conduct the investigations. Criminal sanction, criminal code. Respectfully, Madam Speaker, for a statute to have a sanction in it does not transform the entire enactment into a criminal or a penal code or enactment. That too is fundamental to the point of being trite. That is why I'm staggered. Honestly, I am. I don't mean anything.
On a point of order, Madam Speaker, just so that the honorable member understands the point I made. The point I made was not that the proposed amendment transforms the Evidence Act into a penal law. What I'm saying is that provision that is being sought to include in the Electronic Evidence Act ought not to be in that act because it contains a penal provision. And penal provisions should properly be in the criminal code. This is an act that attorneys will be using before the court, that the judge will be using to determine the admissibility of evidence. It is not a law that allows for penal sanctions to be given for violations of the Act. That is more properly contained in the criminal code. Thank you, Madam Speaker.
Once again, thank you, Madam Speaker, for the opportunity. And so I continue. The logical extension of what I think I'm hearing, or I've heard, is that if the primary subject matter of an enactment, say, for example, is the treatment of fruits and their collections, there can be no provision in there in relation to a penal sanction for something done in relation to fruits and their collection. And so I continue, Madam Speaker. So the proposed Section 18 indeed will be to, just following on interventions from the Leader of Opposition earlier, indeed it will be that the Section 18 will be an insertion after after Clause 17, sorry. And there will be the renumbering of the existing clauses accordingly, so that the 18 existing on the draft would be replaced by this 18, and the 18 will become 19, and so on and so forth. I want to stress again, Madam Speaker, to be quite honest, I mean, there is no controversy here. If anything, one should sit back and examine what is before you. This is an added protection. It is a safeguard. Aren't we here to strike the balance? Having said these things, Madam Speaker, I beg to move that the bill shortly entitled Electronic Evidence Act 2023 be read a second time.
Thank you, Member. Thanks to all members for their contributions. It has been moved and seconded that a bill shortly entitled be now read, shortly entitled Electronic Evidence Act 2023 be now read a second time. Those in favor say aye. Aye. Those against say no. The ayes have it. I call upon the clerk to read the bill a second time.
An act to make provision for the legal recognition of electronic records and to facilitate the admission of such records into legal proceedings and other related matters.
Under Rule 45 of the House of Assembly Rules of Procedure 2021, the bill now stands referred to a committee of the whole Assembly to be considered clause by clause. Assembly in committee.
Clauses 1 to 17.
I put the question that clauses 1 to 17 do stand part of the bill. Those in favor say aye. Those against say no. The ayes have it.
Clause 18.
Madam Chairperson, I propose that Clause 18 be amended by inserting after Clause 17 a new Clause 18 as proposed and renumbering the existing clauses accordingly.
Madam Speaker, if I may have the opportunity to ask as to why paragraph 18, the existing paragraph 18 is being deleted as to whether or not it is deemed to be inconsequential, because there is a relevance and a use for that existing paragraph 18.
Madam Speaker, forgive me, I apologize if I expressed it poorly the first time. The proposal is that the amendment is that the insertion of the new paragraph, the new clause 18, and the existing clauses be renumbered accordingly. So what is 18 before you would become 19. So the conflict provision is still there.
Thank you.
Okay, can someone second? So it has been moved and seconded that the bill be amended and renumbered in clauses 18. So from 18 be renumbered for the existing clauses, yes? Those in favor, say aye. Aye. Those against, say no. The ayes have it. Now I suppose you can ask.
Sorry?
There's a
Are
mem-
we on the short title? Sorry.
Clauses 19 and 20.
Sorry, Madam Speaker. As it relates to the amendment to include the new 18, did it go out for consultation, AG?
The answer is no.
Is there a reason why it wasn't originally included?
This electronic evidence bill is the product of an assimilation or amalgamation of different pieces of legislation that they were looking at over time. I can't say that this was not looked at. It was looked at. I'm not sure why it was not put in as part of this, because we are looking at separating two distinct types of evidence legislation. One that would be the omnibus legislation bill, with evidence legislation bill, which is the one that comes after Evidence Act, and one that is streamlined specifically to deal with the emerging technology and instruments and techniques relative to data storage and data protection. And this was in relation to the electronic evidence bill. So as to it being an omission necessarily, I don't think it was an omission. I think it was considered lately that it should have formed part of this bill because it is a function of data protection which this bill seeks to achieve, and it is necessary as a function of data protection.
Sorry. I would just like to note generally as well, I think that it would have been better if we had been provided with this earlier, Madam Speaker, because it really didn't give much time until here this morning right now to be able to read and review it. I do appreciate that the AG did take some time to be able to go through it bit by bit, but I think for it to be properly scrutinized and for consultations to happen, not just with members of the constituency, but just generally, a little bit more time would have been needed than right before this session.
Right. And I wish members to take it in the spirit in which it's intended.
I take it into the spirit in which it's intended.
If as has been suggested, we excise the sanction in relation to judicial warrants, is it that our friends opposite are saying that you will support it without the sanction?
I never said that at any point in time.
Okay.
So I think that that's not what I said, that it would be supported
Well,
without the
certainly it's
sanction.
not what
I
you
never
said,
even
yeah.
said that it wouldn't be supported, but I raised it in that the sanction was included here, which seemed to me a bit out of it based on the intention of it. So that's not what I said, so I want the general public to note that.
If I may as well, Madam Speaker, the larger issue is that the insertion proposes to give powers to the police officer. It says it shall include the power to access, inspect, check the operation of an electronic device, etc. And so these powers that are bestowed in this provision and the criminal sanctions for failure to comply with the provision ought to have gone to the public, because this relates to the potential deprivation of liberty. A fine not exceeding 5,000 or to a term of imprisonment not exceeding 1 year or both. In addition, Madam Speaker, to answer my learned friends, the member's question, it is not simply a matter of removing the penal provision, because the entire provision, certainly in terms of giving powers to the police officer, the judge issuing a warrant, etc., are more properly placed under a different act and not under the Electronic Evidence Act.
Right. Well, my final thoughts on that, I only asked about the provision just to inform myself as to essentially what the kernel of the concern was, not that it should be removed. If one reads the provision, you will see that, one, it is not very lightly granted. A warrant for such an intrusion is not lightly granted. And two, the powers of the police and the sanction that you are reading, if we read it slowly, perhaps we should, flows from a warrant having been granted by a judge. So the sanction is associated with a judicial warrant. The powers of the police is associated with the judicial warrant having been granted. This does not propose anything novel, and for fear of contradiction, which quite frankly I'm used to now, I think this is insubstantial. Insubstantial, because it is incidental to, and it's a function of the protections already granted. That's all I wish to say, Madam Speaker. Thank you.
If I may say, Madam Speaker, the grant of a judicial warrant should not be in the Electronic Evidence Act. If it is evidence that is needed by the court or for counsel on either side to be able to use to enter evidence before the court. And we have to go back to the whole purpose of the Electronic Evidence Act as set out in the objects and reasons is general admissibility of electronic evidence. That's what this is in relation to, not the power of a judge to grant a warrant, etc.
Since there is such concern, I would recommend that we put this back to public consultation, and then we come back to give it its third reading after amendments, yes or no, have been submitted, yes or no.
Madam Chair, this parent bill was at public consultation. Right. Yes, Madam Speaker, craving your indulgence. This was there. No person from the opposition attended that meeting, Madam Speaker. I don't, for myself, see the injury that is being suggested with this amendment. And so I think that it is necessary to move these pieces of legislation along so that we can, get a more robust ability to introduce this type of If the judge is granting a warrant, Madam Speaker, I think there should be some sanction if that warrant is not adhered to. So I have no issue, and I would respectfully recommend, Madam Speaker, that we take this to vote. Thank you, Madam Speaker.
Madam Speaker, if I may, this is my last presentation on this particular issue, because I think that for the government to move forward with the insertion of an amendment that comes to the House without public consultation that deals with the deprivation of liberty of an individual is wrong. It needs to go to consultation, and the issue is not the Electronic Evidence Act, because the member for Valley North and myself would have stood up and said that we support the Principal Act itself. It is this insertion that comes at the 9th hour without consultation and has to do with the possible imprisonment of persons if there's a failure to comply. Furthermore, the judge giving a warrant is not, there's no area for something like that to be placed in the Electronic Evidence Act. This is simply a guide that lawyers and judges use to determine the admissibility of evidence, whether or not evidence comes before the court. That's it, not the judge being able to give a judicial warrant. And so we're not saying that the provisions are not applicable or relevant or necessary, but it's where the provision is proposed to be placed is in the wrong law.
I know we've already, oh, sorry, thank you. We've already taken a vote on this, but to be absolutely clear to the public, I think I am going to need to put this to vote again. Is that satisfactory to the Assembly?
Just for clarification, Madam Speaker, the vote for the Principal Act or the amendment?
If I can just make a comment or two. I think irrespective of the opinions here, what is vital is the precedent that will be set that an amendment can just come to this House on a substantive act the day of being passed or being amended. But, you know.
For the record, that's nothing new. Entire bills have come to this House for passage 1, 2, 3. That's the history of Anguilla, and I have spoken about that. So that is nothing new.
But has it
I take your
happened
point, but that has,
your tenure
it's nothing
of
new.
being
It
Speaker?
has, and many a times it's based on the urgency of the
Well, I
legislation
understand.
required.
I definitely understand. Some things require urgent action. I do understand. But at the end of the day, it's in your hands to make the call.
And I'm told that this is urgent.
Madam Speaker, my understanding is not that there's any opposition to any of the clauses in the bill, but where the clause is located. So that's not even in relation to consultation. That's just a personal opinion on where it should be. I don't think that has anything to do with the working of the House. But we can, if you think is necessary, do the vote again and move forward. Because what is being recommended and consultation, I mean, the vote has already been made, yes, but my point is that the recommendation is to move it. Consultation is separate from that because consultation is asking if it should be included. But the ultimate recommendation is to move it. So consultation won't even solve the problem that's being raised.
Well, I think that's a question for well, maybe the Attorney General. I don't think we are here. We decide what legislation fits, what clauses fit under which legislation. Attorney General, how do you deal with that? Put you on the spot, but I don't.
Madam Speaker, I am on no spot, and I am not interested particularly in any political points here. We have serious business to deal with. At the same time, it is part of my constitutional duty to be balanced. I recognize that in the host of police operations currently ongoing, and those that will shortly come up, this issue of the constitutional guarantee to privacy in relation to data stored on these devices will be, as it is now, almost frequently implicated. The long title gives an indication as to the broad policy, intent, or the animating purpose of legislation. We must look to the text of the legislation to see what it addresses. Now, what has been recommended is simply this. Data stored on these devices, if we accept that, have a peculiar and special treatment that must be given to them because of the nature of these devices. Persons like myself and those who are familiar with the prevailing constitutional jurisprudence in the courts will know that as a matter of case law, what you have before you as provisions in Section 18, particularly the new Section 18 sub 1 and sub 2, are already in case law. That is to say, there must be special judicial approach to electronically stored data and electronic devices. Intrusion, examination, and extraction of that data must require a High Court judge's warrant. The minimum standard for obtaining that warrant is stated in 2, sub-clause 2. The intent of that is the constitutional protections, as the Premier very astutely recognized from the obvious language and juxtaposition of these provisions, that if a warrant is granted by a judge and it is not obeyed in relation to this special permit to intrude on data, there follows a sanction. To jump about today about whether the sanction should be in another act and it should not be here and all of that sort of thing, to me, Madam Speaker, it is really it's in addition to it being tiresome, it's really unnecessary, and it's a misfortune, because there is no nefarious intent behind this. No one is giving the police an upper hand or anything like this. For a matter of fact, I clearly stated that this is to anxiously protect the privacy right of persons who may be the subject of police investigation in relation to these devices. As far as I see it, in terms of your procedure in the House, a vote has been taken. At this stage, committee stage, we are going through the clauses to see whether they form part of the enactment. I think it is for members in relation to this. That is all I wish to say.
My question was, who determines what should be placed in what legislation, what bills? And I don't know that that the Assembly, I don't think, the Assembly determines that, which pieces of, which clauses go into which bills.
Well,
Because I think
certainly
that was
that is to
my-
ask answers. I think even persons on the other side, they know quite well how the process operates and how this is engaged. I mean, to be detained today on this matter, I mean, actually reaches on the petty.
If I may, Madam Speaker, I would ask the member, and it's unfortunate that there seems to be a reluctance to acknowledge that there's obviously an oversight in bringing this bill to this amendment to the House. I understand that what the clerk has said. I do not agree with the position that the vote was taken in relation to paragraph 19. We had no difficulty with the insertion of paragraph 19 after paragraph 18. It is the contents of paragraph 19 that we took issue with. And it sounds to me like supposedly a vote was taken to insert 18 and 19, to move down 19, to insert 19 after 18 without addressing the contents of it. So if that is the case, Madam Speaker, at the end of the day, it is in the government's hand. They are imposing a law or adding provisions without having gone to consultation. We have seen it for the first time yesterday when it was sent to us. And so we have not had the opportunity to address it prior to now, not at any consultation or anywhere else. And it has to do with depriving people. People can go to jail with the insertion of this provision without the public being made aware of it. And if this is the government's position to move forward with that insertion, then so be it.
Madam Speaker, I am now officially confused as to what the issue is. Is the issue the wrong law or the insertion? Because if it is the wrong law, the law will be the law regardless of where it is. If it is public consultation, then you are saying don't put it in at all until you have some sort of feedback.
That was my understanding in the beginning.
Those two things are not, there are about 3 different messages happening, and the more there is a response to the AG, the more the message change. At the end of the day, if the overall position is that we support this bill, but we don't support where it is located, a certain clause is located, consultation has nothing to do with that. Are you suggesting that we go to consultation to ask the public where we should put a specific clause in the general law?
Madam Speaker, this is a legal argument. I understand why the member would be confused. The reality is
Madam
that
Speaker,
if
I
you-
take
Madam
offense
Speaker,
to that.
Madam Speaker,
The
I am a
member-
legislator. I
the
can ask
member-
these questions.
The
Order.
member indicated
Order.
that she is confused, and
Madam
I'm saying
Speaker, the
I
other
understand.
members are not
I am
legal
speaking-
practitioners
I
either.
understand why the member is confused, because at the end of the day, if we had to accept the argument that the member is speaking about, then the Firearms Act could come into the Electronic Evidence Act as well, the amendments to the Criminal Code.
Madam Speaker, my intervention was about you intervened on my
I did not. I waited
time.
until you finish. The
Madam
reality
Speaker,
is,
my
Madam Speaker,
intervention
is
was
that at the
Please,
about-
end of the
members,
day-
we know,
where-
please, stop. We're going to move on.
Thank you, because it is
Madam-
not-
Stop, please,
If I may, Madam
please.
Speaker.
No, you may not, we will move on. Clark?
Given the renumbering clauses 19 to 21,
I put the question. Oh, I already put that question for the renumbering of from 19 to 21, but I'll do it again for the record. For the question that clauses 19 through 21 do stand part of the bill. Those in favor say aye.
Aye.
Those against say no. The ayes have it.
the title,
Yes, Madam Chairperson, I recommend that the title be amended to alter 2023 to 2024.
Madam Speaker, I second. Madam Chair, I second.
So I put the question that the title be amended to read a Bill for Evidence Act 2024 instead of 2023. Those in favor, say aye. Those against, say no. The ayes have it.
The enacting clause.
I put the question that the enacting clause do stand part of the bill. Those in favor? Those against? The ayes have it. The Assembly will now resume its sitting. The member may report.
Thank you, Madam Speaker. I beg to report that the bill shortly entitled the Bill for Electronic Evidence Act 2024 has gone through its committee stage with amendment and is now ready for third reading.
A bill for Electronic Evidence Act 2024, third reading.
Thank you, Madam Speaker. I beg to move that a bill entitled Electronic Evidence Act 2024 be now read a third time and passed.
Madam Speaker, I raise a second.
It has been moved and seconded that a bill shortly entitled A Bill for Electronic Evidence Act 2024 be now read a third time and passed. Those in favor say aye. Aye. Those against say no. The ayes have it. I call upon the clerk to read the bill a third time.
An act to make provision for the legal recognition of electronic records and to facilitate the admission of such records into legal proceedings and other related matters.
Bill read a third time and passed.
A Bill for Evidence Act 2023, second reading.
The member is recognized.
Thank you. Madam Speaker, once again I rise on this occasion to beg to move that the bill shortly entitled the Evidence Act of 2023 be read a second time.
Madam Speaker, I second.
Right, thank you. Although this is a more extensive legislative initiative, the reform intended by this bill is to replace the Evidence Act in total its entirety with this bill. Once enacted, would become the Evidence Act for Anguilla. The Act incorporates at least 15 years to date of reforms in the law of evidence and particularly procedure that have taken place elsewhere, namely in the United Kingdom, Australia, and to some extent in Canada. The bill sets out certain areas of treatment, and it is in 13 parts. Part 1, preliminary section, division of the Act, will address issues of relevancy and the proof of basic facts in proceedings. Part 2 will deal with the special area of admissions and confessions and their admissibility in proceedings. Part 3 deals with statements by persons who cannot be called, that is, the witnesses whose evidence may be vital as capable of proving or disproving something that is an issue in the proceedings, but that those persons are dead or absent for some particular reason or the other, and will deal with statements made under special circumstances, namely accounting entries and public documents. Part 4 is an area of modernization in relation to the admissibility of first-hand hearsay generated by computer systems, in addition to certain first-hand hearsay at common law being uplifted into statutory form. Part 5, of course, before I leave part 4 with the hearsay evidence, there still remains the power of the court to exclude it, even though first-hand hearsay may be admissible. Under the provisions of this bill, the court retains the discretion to exclude it on the basis of justice reasons and the balance of the interest between parties, particularly where proceedings are civil. Part 5. It provides that judgments of the courts, how you can use previous judgments of the court, etc., and their admissibility and relevance in current proceedings. Anterior judgments of the court may be used in proof or in support of assertions that may be in dispute. Now, it provides also under Part 6 for facts that are judicially considered without the need for formal procedures of proof. And it also talks about documentary evidence, the proof of documents, and what and how will those documents, and documents in this form here would be the conventional definition of documents, not the special type documents that are dealt with in the last enactment we discussed just now. That is to say, those that are electronically stored and generated. This does not deal with that. This is the conventional type of documents. Part 7, public documents and what are speaking documents. That is documents, these are documents that don't require any particular proof as to authentication and provenance once they are of a certain type and issued by certain authority figures bearing seals, etc. They are speaking documents and they are accepted as proof of their contents. Part 8, exclusion of oral agreement by documentary evidence. That is a known area, certainly to litigation lawyers who know what they're doing and saying. This area is already dealt with under Part 8. Part 9, an area of concern for most lawyers because it's ticklish, it's the burden of proof. Who has the burden of proof in relation to proceedings, whether criminal or civil? And it addresses the burden on whom rests the proof in criminal cases as to the proof that a party or a witness is lying, etc. It also addresses burden of proof in certain civil matters relative to the establishment of a proprietary interest in property. It deals with the concept of estoppel. Estoppel in law is both a procedural point and one of substance, but in this one here, the statute attempts to deal with how estoppel is operated procedurally in certain circumstances. That is to say, in tenancy and licensees who are in possession of real property, immovable property. General provision as to witnesses and the treatment of witnesses in both courts, magistrates' courts and the High Court, as well as how witnesses on behalf of the government, the Crown, are to be dealt with, and professional communications, attorney-client privilege, etc. These are dealt with there. Part 11 deals with the examination of witnesses, questions to be asked, the rule of finality in relation to cross-examination of witnesses. That is to say, finality is a rule that where the witness has already answered in relation to a tangential question, one cannot put another same question or similar question to the witness. These things have been uplifted and statutorized here. It is a fulsome and very comprehensive treatment under Part 11 of how evidence given in the witness box in live trials, whether civil or criminal, is to be rationalized, accepted by the court, and dealt with, particularly where there is contradiction and conflict. Part 12 embraces other innovations that have been taking place in the last few years, particularly during the COVID period, evidence by electronic communication. It will also replace the present amendments done to the evidence, the existing Evidence Act, because this would repeal and replace it. Particularly the provisions known to most members of the House in relation to the functions of Executive Council and granting permission in relation to live links and so on. That has been removed. That is entirely a judicial function. So no more of these things will be coming to the Executive Council for decision. Part 13 will deal with improper admission and rejection of evidence, and whether that would occasion a new trial. The essence of the improvements would be that, as I indicated before, the reforms that have been made in the law of evidence for civil proceedings and criminal proceedings, particularly in the United Kingdom and Australia, have been considered in making these reforms here. In addition to existing procedures like the awkward one I just mentioned of the Executive Council being involved in the determination of whether live links of witnesses and to be permitted, which really and properly should be squarely a judicial function. These are some of the matters that are addressed as they were intended so to be addressed by this enactment here proposed. So, Madam Speaker, with these things being said, I don't wish to tarry any further, because these innovations and these new reforms by legislative intervention, as we have proposed, are not, in my respectful view, controversial. I commend it to the entire House.
Thank you, Honourable Member. I now invite debate on the merits and principles of a Bill for Evidence Act 2023. The bill, I now open the floor for contributions. The member for Sandy Hill is recognized.
Thank you, Madam Speaker. Madam Speaker, I rise in relation to this Evidence Act 2023. And Madam Speaker, a draft Evidence Act of one form or another has been around for quite some time. And so I'm happy to see that it has finally made its way to the House. You would have seen that the Evidence Act is repealed at Section 188. And so while it is that we did have an Evidence Act in play, those of us who practice before the court would know that the Evidence Act had not been suited for this day and time, meaning that there was a need to upgrade the Act for some time now, and so I'm happy that it's now before the House. I do note, Madam Speaker, that there are no penal provisions in the Act, as is correct, and so I would say that I support this Act as it is, in my view, drafted from the Attorney General's chambers properly. Thank you.
Thank you, Member. Are there any other contributions to this bill? The Single Island Wide Electoral District member, Mrs. Quincy Gomes-Marie, is recognized.
Madam Speaker, thank you. I rise in support of this act and to point out particularly the separation of powers, which was a big concern for this administration upon coming into office, where Executive Council had to grant the process to allow certain evidence to be admitted in court, which was something that we felt uncomfortable with. And we thought it perverted the intention of the separation of powers. And that in particular I'm very happy with. We took the position at a certain point to bring minimal information on the matter, removing who was involved and the details around the case, as was previously the practice, and to regard all of these submissions as accepted, so as to not be seen as Executive Council and ministers of governments being unduly involved in this process. So I think, and apart from it being modernized, this specific change is widely accepted and was something that we were looking forward to for quite some time.
Thank you, member. Are there any other contributions? If there are no other contributions, I invite the mover to respond, please.
Thank you, Madam Speaker. Old people say in the land of the blind, the one-eyed man is king. And sometimes we need to be responsible to our listening public in what we say to them, because what goes around does come back around. Madam Speaker, I'm grateful to honorable members for their contributions, particularly the meaningful contributions that they have made and indicated here in relation to this legislative proposal. As I indicated, it is not controversial, and indeed it should not be, given its objects. One will note that it is largely a procedural enactment. Procedural enactment. So, no controversy there. I'm very grateful to my colleagues for their support in this behalf. Having said that, Madam Speaker, I beg to move that the bill shortly entitled the Bill for Evidence Act 2023 be read a second time.
It has been moved and seconded that a bill shortly entitled a Bill for Evidence Act 2023 be read a second time. Those in favor? Aye. Those against? The ayes have it. I call upon the clerk to read the bill a second time.
An act to further define the law of evidence.
Under Rule 45 of the House of Assembly Rules of Procedure 2021, the bill stands referred to a committee of the whole Assembly to be considered clause by clause. Assembly in committee.
Clauses 1 to 29. 29.
I put the question that clauses 1 through 29 do stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
Clauses 30 to 59.
I put the question that clauses 30 through 59 do stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
Clauses 60 to 91.
I put the question that clauses 60 through 91 do stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
Clauses 92 to 126.
I put the question that clauses 92 to 126 do stand part of the bill. Those in favor? Those against? The ayes have it.
Clauses 127 to 164.
I put the question that clauses 127 through 164 do stand part of the bill. Those in favor say aye. Those against say no. The ayes have it.
Clauses 165 to 189.
I put the question that clauses 165 through 189 do stand part of the bill. Those in favor? Those against? The ayes have it.
The title.
Thank you, Madam Chairperson. I propose that the title be amended to alter 2023 to 2024.
1 second.
Madam Chair, a second.
It has been moved and seconded that the title be amended to read A Bill for Evidence Act 2024 instead of 2023. Those in favor say aye. Those against say no. The ayes have it.
The enacting clause.
I put the question that the enacting clause do stand part of the bill. Those in favor say aye. Those against say no. The ayes have it. The Assembly will now resume its sitting.
Madam Speaker, I beg to report that bill shortly entitled A Bill for an Evidence Act 2024 has gone through committee stage without amendment, with one amendment, sorry, and is now ready for its date.
A Bill for Evidence Act 2024, third reading.
Madam Speaker, I beg to move that a bill entitled Evidence Act 2024 be read a third time and passed.
Madam Speaker, I raise a second.
It has been moved and seconded that a bill shortly entitled A Bill for Evidence Act 2024 be read a third time and passed. Those in favor say aye. Those against say no. The ayes have it. I call upon the clerk to read the bill a third time.
An act to further define the law of evidence.
Bill read a third time and passed.
A bill for Criminal Amendment Code 2023, second reading.
Thank you once again. Madam Speaker, I beg to move that a bill shortly entitled A Bill for Criminal Amendment Code 2023 be read a second time.
Madam Speaker, I second.
Thank you. Madam Speaker, these are targeted amendments to existing legislation, and there are companion amendments proposed to the Firearms Act to be taken with this initiative. Needless to say, its provenance is the urgent need to address the forms of punishment coming out of gun crime in the country, and to send a message that it is not tolerable and that it is very shocking to the collective conscience of the community. It is also coming from extensive discussions at various levels as to what these responses should do and the form that they should take. These responses in the proposed legislation this morning attempts to set mandatory minimum sentences in relation to gun-related offenses under different categories. And the objects and the reasons for the bill can be shortly stated as follows. This bill amends the criminal code to provide for the imposition of a minimum term of imprisonment for specified firearm offenses. Where an adult has been charged with an offense for possession of a firearm, and such person is a first-time offender, the mandatory term of imprisonment would not be opposed. I say that again. Where an adult has been charged with an offense for possession of a firearm and such person is a first-time offender, the mandatory term of imprisonment would not be imposed. For an offense relating to discharging of firearms, the minimum term of imprisonment will be imposed whether or not the person charged is a first-time offender, because that is where the greater risk is involved, discharging the firearm. In relation to persons who are under 18 years, minimum terms of imprisonment will not be imposed if the said person is a first-time offender. That is to be consistent with provisions of the Child Justice Act. I would permit my colleagues to elaborate more on this because of the sensitive sociological nature of it, but these are essentially the objects of the bill. Madam Speaker, I can't resist certainly to observe certain things here. And perhaps, or not perhaps, I'm eager to hear the commentary of the constitutional scholars in relation to mandatory minimum, because this bill talks about jailing people. Yeah? He's telling you that there's a mandatory, which means it's obligatory. Once certain events and certain things happen, is jail. No. Constitutional scholars will tell you this is a dicey area of constitutional law where the mandatory minimum sentences offend the Constitution, etc., whether it excludes judicial discretion and so offends separation of powers and so on. Perhaps we might hear some of those discrete points of constitutional law, but this talks about jail in response to an emergent social phenomenon. So, Madam Speaker, I look forward to the very enlightening contributions of my colleagues on this matter, and I commend it to the whole House.
Thank you, Member. I invite debate on the merits and principles of the Criminal Amendment Code 2023. Floor is open for contributions. The Honourable Member for Valley South is recognized.
Good morning, Madam Speaker. Again. Well, actually, good afternoon at this point. My apologies. Madam Speaker, of course, the bill before us, the twin bills before us, relate to the Criminal Code Amendment and the Firearms Amendment Act. The basis and the requirements held within these pieces of legislation is to impose a mandatory minimum imprisonment specifically for firearms offenses. And as the Attorney General has stated, there is quite a lot of debate, not just within Anguilla, but regionally and globally, about mandatory minimum sentences. But beyond the debate, Madam Speaker, there is legitimate expectation on the part of persons in the public that serious offenses involving gun crime and gang violence are sentenced appropriately. And, Madam Speaker, if I go into the ethos or what mandatory minimums are intended to achieve, you will see things such as deterrence. You will see things such as incapacitation. And when I say incapacitation, it means that persons who are deemed dangerous by the court through virtue of their guilty verdict will be removed from society for a definitive period of time. Now, Madam Speaker, that does not mean that those persons cannot serve longer sentences. If the particular gun-related or firearm offense is quite egregious, the reality is that the court does have the discretion to sentence that person to a longer period of imprisonment. We also talk about, or what is also seen in relation to mandatory minimums, Madam Speaker, is an absolute sentence floor and then predictability of incarceration. And when we say predictability of incarceration, Madam Speaker, what we're speaking to is if somebody commits a specified offense, we all know that the result of a guilty verdict will be jail time. That will be an underline. We also see, Madam Speaker, in relation to mandatory minimums, a benefit which is in the legal journals and scholarly articles speaking directly to the enhanced law enforcement because they provide them with stronger tools to combat gun crime and gang violence. And as we've seen from the gun crime and gang violence report, Madam Speaker, that was produced by the committee headed under the Honorable Member for District 5, or for North Valley, Road North, that part of the recommendations included, specific parts of the recommendations of the Gun Crime and Gang Violence Committee included enforcing stricter firearms sentences. Or in other words, more punitive firearms sentences. And, Madam Speaker, while we can see these aims, whether it's deterrence, whether it's having an absolute floor, or consistency in sentencing, or even deterrence. Well, I actually said that twice, I'm sorry. The key point in relation to the amendments and the mandatory minimums is public safety. The key focus is on ensuring public safety. And Madam Speaker, we understand that addressing this issue of gun crime and gang violence is not simply an issue of putting in place a punitive framework. It also requires interventions on the prevention side. There's a deterrent side, but there's also a prevention side. And that is why, Madam Speaker, it is very important to note and to continue to support interventions that are being carried out under the Ministry of Social Development and Education, such as the Supporting Families program, which targets specifically vulnerable families, families who may be at extreme risk of certain types of deviant behaviors, with children who may be at risk of deviant behaviors, but also in terms of our Family First program, which aims at creating a wraparound support for families in Anguilla. So taken as a whole, Madam Speaker, this Firearms Amendment and the Criminal Code amendments are simply tools in a wider tool belt to address the issue of gun crime and gang violence. And this administration has taken it as very important to ensure that offenses regarding firearms are taken very seriously, and that the messaging required of the public, which is for stronger sentencing, is actually actioned. And that is why, Madam Speaker, I stand in this House today to give my support to these amendments. And I say twin because both of them have quite a bit of overlap in relation to the Criminal Code and in the Firearms Act. So thank you very much.
Thank you, Honourable Member. Are there any other contributions? The member for Sandy Hill is recognized.
Thank you, Madam Speaker. Madam Speaker, I rise in relation to the Criminal Amendment Code, and simply to say, Madam Speaker, that I will make, with your leave, a more comprehensive response in relation to the code along with the Firearms Bill. The code. This is the reading in relation to the Criminal Amendment Code. You right? Yeah, this is the reading in relation to the Criminal Amendment Code, right? Yes, so I'm just making the proposal to you that my representation on this will be combined with the Firearms Code, which I leave. Thank you, Madam Speaker.
The member for Island Harbour is recognized.
Thank you, Madam Speaker. Madam Speaker, it's good to note that, the members on this side, we work like a well-oiled machine, because I had 3 words written on my paper here: prevention, deterrence, and punishment. And I think that the member for Valley South addressed them. But, Madam Speaker, we were here in this House earlier talking about the, the Gun Crime and Violence Committee, and there was a robust report that was produced, and certain recommendations were made, Madam Speaker. And so it's not just about punishment, Madam Speaker. It's about reforms. It's about putting in place, following some of these recommendations, with talked about increasing sporting activities, increasing community activities, Madam Speaker, providing other options, jobs and employment. Also, Madam Speaker, engaging church organizations, civic organizations in the community. But also, Madam Speaker, I talked about law enforcement. And that goes, Madam Speaker, without saying that where there is crime, there has to be some punishment. And while the goal, Madam Speaker, is for prevention, which is described as an act of stopping something from happening or stopping someone from doing something. And while that is the intent, Madam Speaker, in this age that we now live in of increased gun crime and violence, the police are not everywhere, Madam Speaker. And it certainly should be, incumbent upon us as civil society to make sure that, we educate, we encourage persons, our children, our loved ones, to choose the right path. And we provide avenues for them to do so, Madam Speaker. And certainly, with the increased availability of jobs and that have been provided under this administration, there shouldn't be many idle hands for the devil to find work to do, Madam Speaker. But it happens, and we live in this reality. And so, Madam Speaker, we talk about deterrence. And this is described prevention of something like a crime by having punishment to use as a threat or discouraging an action or event through instilling fear of the consequences. Intention is to make one reconsider doing something bad because they know the penalty will be harsh. And so, Madam Speaker, mandatory sentences. It is something that there was a study done here in Anguilla, Madam Speaker, and that study is not, public. But there was someone who came in from the UK and did an evaluation and determined that this may be one of the areas where, if there are mandatory minimum sentences, if you go back to a person can be held for the 72 hours, that these can act as deterrents. But, Madam Speaker, there is some humanity involved here, in that minors, those under 18, the minimum terms of imprisonment will not be imposed if it's a first-time offender. Also, even in adults, Madam Speaker, if that person is caught with a gun, and this is the first time that it happens, the mandatory term would not be imposed. It would be up to the court then, Madam Speaker, to determine what is the set period of imprisonment or fines for that event. But, Madam Speaker, if a weapon is discharged with the risk of harming someone or themselves, Madam Speaker, then this minimum sentencing would be imposed. Madam Speaker, it's only fair. And there may be concerns by persons that this is harsh. But, Madam Speaker, there has to be consequences for actions that are taken by persons where they can harm themselves or others, Madam Speaker. And so punishment, Madam Speaker, the infliction or imposition of a penalty or retribution for an offense, it is necessary in any society, Madam Speaker. And even in this age of grace, Madam Speaker, where we want to be gentle, we still have to make sure that the law has its effect, Madam Speaker. And so we do hope that this message gets out, Madam Speaker, that the minimum sentences, and I hope people don't confuse the word minimum to mean that it's a small sentence, Madam Speaker. Because the numbers are in there, 3 years, 7 years, Madam Speaker, for having a firearm, even just possession of it, if it's not your first-time offense. And certainly discharging it, the years of incarceration, imprisonment will go up, the fines also, Madam Speaker. And this, Madam Speaker, the intent is to be a deterrent, so that those who choose this way of life would reconsider their ways, Madam Speaker. And so I want to thank the Attorney General's Chambers for being able to bring this amendment and get it to the House, Madam Speaker. I want to thank all those who are involved in this decision-making, Madam Speaker. I want to thank the National Security Council for being able to take all these events that are happening and to come up with a plan, Madam Speaker, that there'll be more coming out of this later on in this month and next month in terms of the robust efforts that will be made to decrease this scourge of gun violence that is happening in our paradise, Madam Speaker. So I support this wholeheartedly, and will also say I support the amendments to the Firearms Act, which will follow this one. Thank you very much.
Thank you, honorable member. Are there any other contributions? If there are no other contributions, I invite the mover to respond, please.
Thank you once again, Madam Speaker. I know it is my birthday, but it seems to be a day of many surprises. I mean, I'm surprised on one end, and I am surprised and somewhat disappointed on one end here as well. I thought there may have been some scholarly constitutional interventions on the fact that we are mandatorily making provisions to jail people. I hear none of that. But that seems to be quite in order. That's good. Madam Speaker, having said that, I wish to say that before I move on the second reading, there is no malintent behind these provisions. There is an urgent need to be serious about something because we have a serious problem. Petty approaches and that sort of nonsense get you nowhere. In fact, it's looking rather silly. These are serious things that you need to deal with in this society. This is only one end of addressing it. Part of the problem is sociological, and I'm sure, I know to some degree, the ministry is trying to attend to that. That too requires funding, sociological and welfare interventions in homes and families. That requires funding, and there may need to be some omnibus bill legislation coming to this House to introduce and propose a multifarious approach to that social problem, because crime and violence can't be taken in isolation. Yes, today we are making provisions to show that the penal response to the growing delinquency is going to be a sharp and serious one. It's a signal that we're sending. But it is not the full achievement of solving the problem, but it certainly goes some way in addressing the problem. I just wish to say that. Having said that, Madam Speaker, I beg to move that a bill shortly entitled the Bill for Criminal Amendment Code 2023 be read a second time.
Thank you, member, and thanks to all members for their contributions. It has been moved and seconded that a bill shortly entitled A Bill for Criminal Amendment Code 2023 now have its second reading. Those in favor say aye. Aye. Those against say no. The ayes have it. I call upon the clerk to read the bill a second time.
An act to amend the Criminal Act to provide for the imposition of a mandatory minimum term of imprisonment for firearms-related offenses.
Under Rule 45 of the House of Assembly Rules of Procedure 2021, the bill now stands referred to a committee of the whole Assembly to be considered clause by clause. Assembly in committee.
Clauses 1 to 4.
I put the question that clauses 1 to 4 do stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
The title.
Move for amendment. Is he going to amend the title?
Yes, Madam Chairperson, I would move that the title be amended to alter 2023 to 2024. Thank you.
I second, Madam Chair.
It has been moved and seconded that the title be amended to read a bill for criminal amendment code 2024 instead of 2023 and do stand part of the bill. Those in favor say aye. Those against say no. The ayes have it.
The enacting clause.
I put the question that the enacting clause do stand part of the bill. Those in favor say aye. Those against say no. The ayes have it. The Assembly will now resume its sitting.
Madam Speaker, I beg to report that the bill shortly entitled "A Bill for Criminal Amendment Code 2024" has been through committee stage with one amendment and is now ready for third reading.
A bill for criminal amendment code 2024, third reading.
Madam Speaker, I beg to move that the bill entitled Criminal Amendment Code 2024 be read a third time and passed.
Madam Speaker, I second.
It has been moved and seconded that a bill shortly entitled "A Bill for Criminal Amendment Code 2024" be now read a third time and passed. Those in favor? Those against? The ayes have it. I call upon the clerk to read the bill a third time.
An act to amend the Criminal Act to provide for the imposition of a mandatory minimum term of imprisonment for firearms-related offenses.
Bill read a third time and passed.
A bill for Firearms Amendment Act 2023, second reading.
Madam Speaker, it appears that I have come to the end of the batting order and the innings that the Premier has allotted to me. I beg to move that a bill shortly entitled "A Bill for Firearms Act Amendment Act 2023" be read a second time.
Madam Speaker, I second.
Thank you, Madam Speaker. Madam Speaker, I wouldn't detain honorable members in this House any further, save and except that I will shortly indicate the objects of the bill. And it has been indicated before in detailing the last amendment introduced to this House moments ago, that these bills are companion measures seeking to address the same mischief and also to introduce the same response legislatively in the way of sentencing, minimum sentences. Objective and reasons can be shortly stated thus. This bill amends the Firearms Act to provide for the imposition of a minimum term of imprisonment for specified firearms offenses. Where an adult, similar to the introduction of the measures in the last bill, has been charged with an offense for possession of a firearm, and such person is a first-time offender, the mandatory term of imprisonment will not be imposed. For an offense relating to discharging of firearms, which is more serious, that's the ill that's the mischief we're trying to address, the minimum term of imprisonment will be imposed whether or not the person charged is a first-time offender. In relation to persons who are under 18 years, minimum terms of imprisonment will not be imposed if the said person is a first-time offender, as I indicated, consistent with provisions of the Child Justice Act, which is legislation that is existing and in operation. Likewise, as with the last amendment we introduced, this measure should be looked at in the same light as the one we just passed. And having said that, Madam Speaker, I commend this amendment to the Firearms Act to the whole House.
Thank you, Honorable Member. The floor is now open for contributions to the Firearms Amendment Act 2023. The Honorable Member for Road North is recognized.
Thank you, Madam Speaker. Good afternoon to everyone, those here in the House and to everyone listening. Madam Speaker, We're here today. We've dealt with a number of bills, some to modernize our court system, and just bringing it up more in line with technological advances, bills to protect persons' rights. And now we are here for the Firearms Amendment Act. Madam Speaker, if you look across the region, just about every Caribbean country is battling with the rise in gun crimes and violence. And many of them are trying to find ways to deter persons from getting their hands on guns and committing acts. And one of the ways that a lot of these countries have looked at it is by introducing increased sentencing as it relates to gun activity. Some of these countries, like St. Kitts, for example, they're looking at increasing their penalties from 15 to 25 years. I think in Jamaica, they're looking at a maximum of 15 years. I think in Antigua, you can serve up to 25 years for gun-related crimes. And, Madam Speaker, it may be argued that our new mandatory sentencing might not be enough when you compare it to some of our Caribbean brothers and sisters. But there are also numerous studies, Madam Speaker, that states that increasing the severity of the punishment does not necessarily deter crime. And even if you look around the region, Madam Speaker, saw an article just the other day where Trinidad is now putting their army, their defense force on the streets to help combat gun crime and violence. The same is in Jamaica, the Bahamas, and a number of our regional countries, Madam Speaker. They're looking at additional ways, not just the sentencing, of how we can combat this scourge that is embattling the entire Caribbean region. And I think we can all agree that the penalties as they were before in Anguilla were way too lenient. Persons charged for gun crime 2 and 3 times getting away with a fine. Madam Speaker, that was definitely too lenient. As a matter of fact, Madam Speaker, one of the recommendations coming out of the Gun Crime and Violence Committee was for the criminal code and firearms legislation to be revised. And while these amendments are overdue, Madam Speaker, they are indeed necessary. But that is only one of the 20 recommendations that the committee made, because we all recognize that this needs to be a multi-pronged approach from community, from our Ministry of Social Development, from the AG chambers, from the police force, that it needs to be a multi-pronged approach to combat the rising crime in Anguilla, especially as it relates to gun activity. And we see this part of this legislation also going in hand with the increased numbers that will be added to the police force, because you can have all the good laws you want, but if there's no one to make the arrest, no one to put a person behind bars, these laws are just, written on a piece of paper. So that everything needs to be in hand, everything needs to be in tandem for us to accomplish what all of us wants to accomplish. And Madam Speaker, this legislation, for lack of a better term, it tighten up the loopholes, especially when it comes to repeat offenders. So rather than they just get a fine if they're found guilty, they can now be faced up to a mandatory 3 years if it goes to a magistrate court, 7 years if they have to go to the high court. And I know a lot of persons just hear the catchphrase is minimum, maximum, but this is if you're found guilty. If you come to the court, you'll go to the court system, you'll be awarded a fair chance. And if this is your second offense, the court is saying, bam, I have no choice. If it's at magistrate court, you will serve 3 years. You go to the high court, you're found guilty, you get your due process, you have to serve a minimum of 7 years. And Madam Speaker, the other day I was listening to a sermon by my old Sunday school teacher, Reverend Lindsay. So he was giving an analogy that Anguilla is like an ostrich. And 2 things about the ostrich he was saying: it's an animal that can run very fast, and it hides its head in the sand. So I just want to say quickly, as it relates to this issue of gun crime and gun violence in Anguilla, I don't think we are an ostrich. I think we have, as a people, have recognized we can't bury our head in the sand and we can't run away from this problem. And this is one of the ways we are seeing that we need to deal with this problem, Madam Speaker. Not the only way to deal with the problem, Madam Speaker, but one of the many ways. And we have seen, as we have mentioned before, even from the recommendations coming from the Gun Crime and Violence Committee, that a lot of these things have already started taking place, because this administration have also recognized that we cannot leave a few bad apples that are here in this country spoil the entire bunch. And I don't want to just use the term bad apples, because even sometimes bad apples do go bad for different reasons, but the point is just a few causing the mayhem in this country, and we need to find different ways to stop it, not just by the laws, not just by the police, but actually addressing other social issues. So as I was saying about my former Sunday school teacher talking about Anguilla being an ostrich, I beg to differ a bit, because I don't think we are ostrich. We might have been ostriches some time back, but we have now recognized that this is an issue. And we have recognized this issue, staying along with the flying birds analogy. Well, ostriches don't fly, but staying with the birds analogy, we have recognized that we need to keep the vultures, because what vultures do, they recognize the sick and the injured, and they prey on the sick and the injured. So we have to also recognize, not just to be ostriches, but to also keep the vultures away. And I think we are at a good place, Madam Speaker, not a great place, but the only way you can improve on something is to recognize that you have a problem. And I think by bringing these laws, bringing these amendments to the legislation, to the House of Assembly, recognizing that we do have a problem, recognizing that it do need to be addressed. And that is always the first step, Madam Speaker. We have a long way to go. We are not close to getting the problems fixed, but every long journey begins with a first step. So, Madam Speaker, I just want to wholeheartedly give my support to these amendments that came before the House here today, and thank you.
Thank you, Honorable Member. The Single Isle White Electoral District Member, Mr. Kyle Hodge, is recognized.
Madam Speaker, good afternoon to you, good afternoon to the House, good afternoon to the people of Anguilla. Madam Speaker, I rise to contribute to this debate as it relates to this bill, a bill for Firearms Amendment Act 2024. I think it should read that. Madam Speaker, these are serious times. The gun crime situation in Anguilla has gotten a lot more sophisticated. And in recent times, Madam Speaker, it has reached to places that we never thought it would have gotten to. And because of the seriousness, Madam Speaker, of gun crime, irrespective of location, irrespective of how sophisticated the acts are becoming, or how brazen, gun crime on a whole must be nipped in the bud. And Madam Speaker, this response, and as the member for Rodnard said, it needs to be a multi-pronged approach. But this is one part of that approach that I rise to support. And Madam Speaker, hopefully the intention of the amendments here today would lead to a slowing down, an eradication, if possible, of gun crime, gun-related crimes in Anguilla. But Madam Speaker, this, and all of us in here knows this, these amendments will not be the final solution. It's going to take, Madam Speaker, a collaborative approach. That is, the Parliament, what we are doing right now, the police, the Royal Anguilla Police Force, the church, families, and then finally, Madam Speaker, it's going to take our communities to go back to being communities. I think we have lost, over the years, we have lost the true essence of what it means to be a community, what it means to be a neighbor, what it means to be your brother's keeper. We have lost the meaning of those things. And I dare say, Madam Speaker, that the entire Anguilla is a community. We are all one people, we are all one family. We are connected. From east to west, north to south, we are connected. So, Madam Speaker, that collective effort, a consistent collective effort, is the only way that we will begin to make a dent and be able to realize a reduction or eradication of this type of crime. And what we need, Madam Speaker, we need a community and a people that shows more love, more support, more respect, and more care for one another. But we also need, Madam Speaker, in the business of everything, because we are all consumed being busy. What we need and what the young people of this country is desirous of is quality time. Time from each and every one of us. Time from our religious leaders. Not just to go in church and preach or someone for an hour, but time from all of us being intentional as it relates to having conversation, as it relates to showing up and showing people, especially the young people, that we are here for them, that they have our attention, that we are not too busy. And I say we are not too busy making money and trying to make ends meet, that we can carve out some time and teach and train and correct. Because a lot of the times, Madam Speaker, it is because there's not that correction, that reinforcement of what is right and what is wrong, and this path is the wrong path. That consistent preaching, talking, conversating with our people, Madam Speaker. And we have gotten to this point, Madam Speaker, where it's difficult. It's very difficult, and I must admit it's very difficult to stop. Because where we are now, and this is not just me speaking, the committee, Madam Speaker, under the leadership of Mr. Merrick Richardson, we would have gone to communities to speak to people that are affected by gun crime. And the biggest challenge right now is fear. F-E-A-R. Fear. So when a young man finds himself being armed, it's not because he wants to arm himself. It's because he's afraid of what might happen if he isn't armed. So fear, the issue of fear, cannot be resolved by this amendment. The amendments are good, and I support the amendments. But eliminating fear, and I don't have the answer as to how to eliminate fear. But I'm just relaying, Madam Speaker, that through our conversations, that is the single biggest concern of the youths who are armed. So, Madam Speaker, investing our time with the young people, investing our time in the communities, it can go a long way as it relates to bridging the gap. So, Madam Speaker, as it relates to the bill for Firearms Amendment Act, what I also want to say is that the collective effort by Parliament, by government, by opposition, by the Royal Anguilla Police Force, by us, Madam Speaker, coming to this House and supporting these amendments, we also have to display and have to guarantee to the general public, especially the young people, we have to guarantee fairness. 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 As it relates to the application, as it relates to the policing of these amendments. Because we have had injustices in the past. And one thing for sure, the young people, they pay attention to when there are injustices. There was a very sad incident in West End years ago where a tourist was able to leave. They look at these things. So the application in us being able to guarantee fairness, that no one side gets preference when convicted, or when a law is broken, or when a crime is committed. No one side gets any kind of preferential treatment. We also, Madam Speaker, have to guarantee that police corruption is stamped out. And I've heard the Commissioner speak on it, and I believe he means business as it relates to any possibility of corruption in the force. If we want amnesty, and I believe, I haven't heard it as yet, maybe before the debate is closed, I believe that a period of amnesty should also follow suit in short order, so that we can get those who are willing to change, those who are willing to believe that the system can really work for them. But they have to have that belief. So I do hope that a period of amnesty is given to unlicensed, unlawful firearms that exist right now in our community. So, Madam Speaker, I want to close by giving a short story, because our efforts here today will be in vain if our homes are not fixed, if our communities are not fixed. And I met an elderly gentleman some time ago, several months ago, that explained to me the generational issues that we see happening in Anguilla. He would have mentioned to me, Madam Speaker, that in his time, and his time would have been my grandfather's time, my grandmother's time. that in their time, the man of the home used to go out and walk. In fact, the man of the home used to leave the island to go to work in order to bring back something to the household, while the mother of that home would pay attention to raising the children, in addition to doing maybe some subsistence farming to keep the family with food. So that's that generation, which is my grandparents' generation. He went on to say, his children, which now would be my parents' generation, both parents had to work in order for the family to survive. Both parents had to work. So the mother would have to leave home to work. The father would leave home to work. This is all in efforts to have a comfortable lifestyle. So that's that generation, my parents' generation. The last thing he said, when looking at the various, this is 3 generations, when looking at the 3 generations, he said, you know what I see happening today? This generation, not only does both parents have to work, but both parents possibly have to work 2 jobs. The community is working. The elderly person who's your neighbor or who's in the community, that person is probably working too. So who is looking after the children? Who is looking after the youth? Everybody's busy, everybody's out. And this goes back to the very beginning. We have to find a way to go back to community. Because parents alone will not do it either. I love when I take my children to my grandmother's house. As tough as it is, because she's a tough woman, as tough as it is to hear her discipline my kids, I have to allow it. Because I alone, my wife alone, we can't be doing all the talking. It takes more than one. It takes a village to raise a child. And that village is the parents, family members, neighbors, and the community. If we ain't going back to that and finding a way to figure it out, we in trouble. So, Madam Speaker, I just want to thank you for this time, this opportunity, and thank the members of the committee, those members who were invited to be a part of the committee, and also the members on both sides of the House. Thank you.
Thank you, Honorable Member, for your contribution. The Single Isle White Electoral District Member, Mr. Kenneth Hodge, is recognized.
Thank you, Madam Speaker. I just want to extend birthday greetings to Honorable AG and to say, AG, I probably will disappoint you today because I will not deliver the scholarly exposition that you have been looking for. But nonetheless, Madam Speaker, I rise in support of this piece of legislation. Madam Speaker, a week or so ago, I was at a banking institution and a good friend of mine came up to the car very agitated. And she said to me that she is very concerned to leave her house at any time now because she is afraid for her life. She doesn't know what will happen when she leaves the house. And she was visibly agitated. And that disturbed me, Madam Speaker, because I think we take freedom of movement as one of our fundamental rights. And Madam Speaker, 2 other instances I wish to bring before this Honorable House. A couple evenings ago, I had retired for the evening, and I got a call from 2 persons in the Farrington area asking me if I had heard the shots fired somewhere in the lower Farrington. I hadn't, Madam Speaker, but I did call the police. And they did confirm that there were some shots fired in the area. And then sometime shortly after that, a couple days after, I got a very long phone call from another resident of the Lower Farrington who said that he was lying in his bed and he heard a flurry of shots coming from, I think he said, somewhere over south of where he lived. And I further found out that it was somewhere over in the Anitou Bay area. We know the area is Anitou Bay. And that was confirmed by a number of others. So I've said that to say, Madam Speaker, that this piece of legislation is timely. We have to begin to put a brake, so to speak, on this indiscriminate behavior. And it's not only happening in Anguilla, Madam Speaker, it's happening all around us. But particularly in Anguilla, Madam Speaker, it's a way of life that is foreign to us as Anguillians. Madam Speaker, 20, 25, 30 years ago, I can recall we used to drive around the beaches in the late evenings, late nights, sometimes 10, 11, 12 o'clock in the night. You go in the forest, you park up on the beach. Those days, Madam Speaker, are way behind us. We're not going to do it because we are fearful at this time. Madam Speaker, I was happy to be a part of the Select Committee on Gun Violence, and I saw all the various interventions that transpired and all the recommendations, Madam Speaker. And it concerns me that we are trying to put in place remedies to correct situations, Madam Speaker, that I would say almost comes late. Because these behaviors are the actions that cause a lot of these young people to behave the way they do, were inculcated in them not yesterday, but 10, 15, 20 years ago, Madam Speaker. And we tend to lay the blame on the church, the community, Madam Speaker. But today in this honorable house, I want to lay the blame on the home. Because a lot of parents have abdicated their responsibilities as parents to the church, to the school, to the courts, to the police, even to the juvenile home we have here, Madam Speaker. And I say that because I saw a particular instance a couple of years ago at a shop where a young person, he couldn't have been more than probably 6 or 7 years. And his grandmother was shopping with him. And Madam Speaker, if you had heard the language of that little child with that grandmother, shocking language. And in my day as a young person, if I was behaving that way, I could tell you what would have happened to me there and when I got home. These things now are taken for granted. Sometimes we laugh, we say it's cute, Madam Speaker, but these are the beginnings of these behaviors that are manifesting themselves later on in life. Madam Speaker, I love to watch cartoons, but a lot of these cartoons, Madam Speaker, with the Bugs Bunny and the Roadrunner, involve shooting up people and blowing up people and throwing rocks on people. And Madam Speaker, these are the kinds of things, it may sound humorous, but these are the kinds of things that our children, our young children, sit for hours before the television, saturating their minds with these things, Madam Speaker. And then we add to that this situation where parents may be out, working or other engagements, and the children are finding comfort and companionship on the block, where they are now being actively exposed to these higher forms of behavior. So, Madam Speaker, I support this bill, but I'm also saying that this is not going to be a remedy for something that continues to beset us, and we're going to have to go back to the basics of home and community, Madam Speaker, where I can correct my neighbor's child without fear that that neighbor is going to come to tell me what parts I was born and I wasn't born in. These are the realities of life, Madam Speaker. Otherwise, we're not going to have a big enough jail to hold these people. We're not going to have enough police to go out and police this country, Madam Speaker. This is a wake-up call. And today I support this bill, and I also want to issue a call for parents, Madam Speaker, to go back to being parents, to go back to the values, the customs, the mores that characterized us as Anguillians in those early days where we looked out for each other, Madam Speaker, where we found time to spend time with our children, to model the behaviors that we expect of our children, Madam Speaker, to help them to make the choices. And you know, Madam Speaker, the bright light in all of this is that these persons are not an overwhelming majority. They are a very small minority of our community. And that is the bright light, that so many of our young people are excelling in music, in sports, in drama, in culture, that are demonstrating the positive ways of contributing to this country, Madam Speaker. So with those few words, I want to indicate my support once again for this legislation. And I look forward, Madam Speaker, to the community, which includes all of us, being not so quiet, being open and vocal and saying what we see, where it happened, helping the police to help keep this country secure. Because someone said to me, Madam Speaker, the day that a stray bullet hits a tourist in Anguilla, all of us gonna bawl, because it's gonna affect the entire economy of this country. So, Madam Speaker, this bill today is a wake-up call for all of us. Thank you, Madam Speaker.
Thank you, Honorable Member. The member for Road South is recognized.
Thank you very much, Madam Speaker. I too rise to support this Firearms Amendment Act 2023. I honestly believe that this is one of these bills and that comes to this Honorable House, Madam Speaker, that will have bipartisan support. And from the presentation that was made by the single-elected member, you will realize that it does have bipartisan support. And I think everyone would recognize the importance not only of this bill, but of what everyone had to say prior. And again, I would like to join the Honorable Kyle Hodge in his gratitude for the leadership of the Honorable Parliamentary Secretary, Mr. Merrick Richardson, on really pushing forward on this and many other things that you will see coming to this House and also coming to Anguilla, Madam Speaker. And I want to say, Madam Speaker, that this is an island that is 3 miles wide at its widest point, 16 miles wide at its longest. In all metrics, this is a small island. It's an island of less than 15,000 souls, Madam Speaker. I'm not talking about visitors, I'm talking about inhabitants on this country. And so we are a very small, close-knit community. And you'll find across this island that we have significant familial ties. Case in point, Madam Speaker, I am the cousin of the Honorable Cora Richardson Hodge, member for Sandy Hill. A lot of people may not know that. I am also the cousin of the Honorable Cardigan Connor, member for West End. He's a Hughes, but he happens to carry Connor, Madam Speaker. And I mean, he's free to correct me if I'm wrong. His dad is a Hughes. He's a brother of Sherman Hughes. I am also the cousin of the Honorable Perrin Bradley, Madam Speaker, whose mother was a Hughes before she became Bradley. And I know, without a shadow of a doubt, that the Honorable Quincy Gums Marie and the Honorable Cora Richardson Hodge are not second or third cousins, but first cousins, Madam Speaker. And Mr. Joash Lennox Proctor, he has roots in South Hill, Madam Speaker. Polly Lewis and the like, who is also a cousin of mine. So what you'll note, Madam Speaker, is that whether you're living in Island Harbor or whether you're living in West End, there's familial ties throughout this country, and I'm sure some of those persons who have committed gun-related crimes and have not been caught perhaps may have shot their cousin or may have shot their sibling that they did not know about, because as you know, I have a sister, older sister, and a lot of people in Anguilla did not know that. So sometimes we have siblings that we are not even aware of, Madam Speaker. So it says that we need to stop this scourge, and we've been talking about this for a very long time, Madam Speaker. In 1999, I wrote an article, 1999, yes, I wrote an article in the Light newspaper that was owned by George Hodge entitled When Will It Stop? And it wasn't about gun violence, but it was just about the rock throwing and what have you. And so I stayed very close to what was happening in Anguilla as it relates to proliferation of violence, in particular gun-related violence. There was a time that I kept names and numbers and stats, and I won't speak to them here, Madam Speaker, because the last time I spoke to them, I got myself beat up. So I won't speak to that now. But what I can say this, without a shadow of a doubt, Madam Speaker, that prior to 2003, if you go back to the 1700s to 2003, you could not find 10 murders in Anguilla, Madam Speaker. You could not find 10 murders in Anguilla. And from 2003, Madam Speaker, onwards, you saw the escalation of violence and gun-related violence. It was in 2003 when we lost a young lady from the Island Harbor area, a promising young lady who was in high school at the time, Madam Speaker. I don't know if you can recall. And we lost the life of Roger Pressure King Clark and a number of other individuals, Madam Speaker. And what I noticed in terms of gun-related proliferation of gun-related crime in Anguilla from 2003 onwards is that every time you have economic expansion, the economy was doing well, gun-related crime escalated. And every time you had a time when the economy started to plummet, the gun-related crime also fell. And I was trying to analyze as how is it that this is possible. And what I came to the realization is this, that persons may have petty arguments and petty differences in high school, the Albina Lake Arch Comprehensive School. But once they leave school, graduate from school, and they had the ability to earn by working, mostly in the hospitality sector, Madam Speaker, and they start to earn that money, one of the first investments that they made was a gun. And this is why you've heard me say many years, buy blocks, not guns. And if it is you don't have land to put blocks on, start paying down on land, start to work towards that goal. But for some reason or the other, this is not the ambition of young men in particular, Madam Speaker. And Madam Speaker, so this Firearms Amendment Act comes to this Honorable House today, receiving bipartisan support. But as previous members have said, this is not the only solution. And that is why you will see that the Honorable Premier and the Government of Anguilla have made a commitment to a CCTV across this island, Madam Speaker, starting this year. And you will see over the next year and further on that more investments will be made in terms of CCTV to increase our capacity to ensure that whatever blind spots that they may be covered. So I don't like to use the word police state, but for all intents and purposes, we're going to have Big Brother watching all our moves. All the sneaky links in the late nights will now be captured on CCTV. You know, everything will be seen, Madam Speaker. And all our moves will be watched, similar to how it is in London and other metropolitan countries, Madam Speaker. But what it does is not only reduces the proliferation of crime, but also helps with the apprehension when these things occur. Because criminals and criminal minds, Madam Speaker, are always thinking about how they can get away and what they can do to escape the law. And as you can see with these minimum sentences, we may also have to invest in our prison capacity, increase capital expenditure in terms of building more cells and more capacity at His Majesty's prison, Madam Speaker. That in itself comes at a tremendous cost to the taxpayers of Anguilla. So there's other consequences and other knock-on impact that this bill will bring, Madam Speaker. And Madam Speaker, I often hear persons say that people justifying it, Madam Speaker, and I call it justification. Justification for gun-related crime in Anguilla, that people don't have nothing to do, that young people don't have nothing to do. I totally shun that view, that justification for any proliferation of gun-related crime in Anguilla, Madam Speaker, because you and I know, we were born in the 70s, maybe you're a little older than I am, but most of us have been born in the 70s and the 60s, and you know, Madam Speaker, we had less to do back then than today. And I often refer to my great, wonderful uncle, Uncle Freddie, who's 97 years old. Mind is as sharp, his body may be leaving him, but his mind is as sharp as it was 1930, Madam Speaker. He was born in the year 1926, Madam Speaker. And if you read his books, Madam Speaker, you'll see the tremendous hardship that those before us had. Tremendous hardships. Had to be out working, going across the waters, Madam Speaker, at the age of 12. And even Charlie Gums, who died at 103 years old. I was listening to a program ran by Brother Lee Carl, culturally used many years ago when Charlie was with us. He was over 100 years at the time. And he spoke of his mother sending him to San Pedro de Macorís to cut canes in the cane fields, Madam Speaker, at 9 years old, Madam Speaker. Our forefathers had a tough time, Madam Speaker. The number of persons, Madam Speaker, I've sat with my uncle, and he has given me stories because he was a man of the ocean, a man of the sea. And the number of families in Anguilla that lost the males, the fathers, the uncles, the breadwinners to the ocean, Madam Speaker, is unbelievable, Madam Speaker. When I sit and I hear the stories of how many men was lost, because back then, you didn't have any real navigational equipment, Madam Speaker. My grandfather was a sailor who died on the same year I was born on August Thursday down at Meads Bay, Madam Speaker, 1971. And he had navigational equipment, but unsophisticated. And as a little boy, I found them in his old house, and to this day I still have them, his old compass and sextant and all of those equipment, Madam Speaker. Very primitive equipment, Madam Speaker. They could not tell what would be happening out there in the ocean. And a lot of them went out to fish or to go to St. Kitts, and sometimes all the way up to South America, Madam Speaker, without any real navigational equipment and no engines to their boats. A lot of them were lost at sea, Madam Speaker. And then who raised the children? You read about the stories of how difficult things were in Anguilla and how inflation during the Second World War impacted us, and how difficult the food was, and how expensive food was, Madam Speaker, here in Anguilla, and what they had to do to survive. And so I don't subscribe to the notion that there was nothing to do, because when we grew up, we didn't have much to do, but we made rondas. You remember rondas, Madam Speaker? We played cricket. Sometimes we didn't even have a ball. And I know Carter can remember this. Sometimes we made our bat out of coconut, the stalk from a coconut, Madam Speaker. We did whatever we could to entertain ourselves, but once sundown came, we had to be inside. There was no light. There was no electricity. We got electricity in South Hill when I was already in high school, Madam Speaker. So there's a lot less to do, Madam Speaker. So that is no justification. Stop justifying these actions, Madam Speaker. For a young man to leave school, become gainfully employed, and invest in a gun and shooting it at persons, not robbing and so forth, but shooting at persons, and even if it's robbery, and you making a justification that they don't have nothing to do. Because, Madam Speaker, today, We have the Anguilla Enhancement Project. If you want to get involved in something that will contribute to society, you have the Red Cross. You have a number of different programs that you can enter into, Madam Speaker. Today, you have kids every day being trained by coaches on the track, Alexis, Ryan, and the like, Angela, and the like, Colin, Liddy, and the like. So many of them, Samaro Richardson, who puts a lot of his time with the children, Madam Speaker, and particularly the soccer players, Vance Fleming, and all of these people who contribute so much of their time. I see them, Madam Speaker, contributing of their time. Nigel Connor and the Connor brothers from over there in Sonnegrong, Madam Speaker, on a Saturday with soccer and so forth. So many programs, Madam Speaker, contributing of their time, Madam Speaker. And Madam Speaker, you have the sailing school. And you have Richard Stevens and his team with All Nations Swim Club, Madam Speaker. There's a Sunshine Theater, Madam Speaker, if you want to get into performing arts. The Anguilla Tennis Academy, down there in Blowing Point, Madam Speaker, which also offers scholarships to kids who don't have the financial wherewithal, Madam Speaker, to attend the Anguilla Tennis Academy. You have the golf program for the children at the Aurora Avalon Links Golf Course, Madam Speaker. You have Timothy Richardson, who for decades have been given his time to train youngsters in terms of cycling. And one of his protege, Hassana Hennis, recently signed a professional contract in France, Madam Speaker. We have so many examples, Madam Speaker, that are featured in the Blowing Point Ferry Terminal. Persons like Omari Banks and Jamal Hamilton, Ras Bucket, Zarnell Hughes, Cheryl Proctor, Kiki Herbert Harrigan, Madam Speaker. So many examples of what if you can focus your time and your energies towards sports, even in the absence of facilities, you can make a mark, not only in Anguilla, but in the world, Madam Speaker. Lennox Vanderpool, Madam Speaker. Kimberly Southwell, Daphne Jacobs, if you want to get involved in music. Justin Richardson and all these people will volunteer the time. We have the Anguilla Music Academy, ran by Darius James, Madam Speaker, down there in South Hill. There are so many things, positive things that you can get involved in, that parents can get their children involved in, Madam Speaker. So there's no excuses. There's no justification for taking that hard-earned $1,000 or $1,500, or whatever it may cost, Madam Speaker, in purchasing a gun to do harm to your cousin and perhaps your sibling, Madam Speaker. There's no justification for it. And now, when you're caught, you call the politician. That's the first person they call, especially the parents. You know, my son just got locked up for a gun and he really didn't want to have the gun, but I need you to help me with some bail, Madam Speaker. And I want to make it clear here again, you're on your own. If you ever do that, and I said it time and time again, Madam Speaker, even if it's my child, they're on their own. Because there are better choices that you can make. If you're between the ages of a toddler to 18, Madam Speaker, and then after 18, this legislation speaks to the age of 14, Madam Speaker, and you're after 18 and you decide you get a job, that this is the route that you're going to go, this is the investment that you're going to make, why are you calling your elected representative at that point, asking to stand surety in the court? Don't call me. Hey, make no reservation about it. Don't call me, because I'm not coming. And I would hope that every single member of this honorable House and those who are vying for political office make that stand, Madam Speaker, because we cannot afford it. One person getting shot in Anguilla is one person too many. One illegal firearm in Anguilla is one firearm too many, Madam Speaker. I have been told time and time again that I should apply for a gun license. I am so afraid of guns that I'm afraid that even if I have one, I go on the range, Madam Speaker, I might end up shooting my finger off. And I'm kind of awkward too, so I know I'll never learn how to shoot, Madam Speaker. So, Madam Speaker, what I'm saying is that we should not be here talking about firearms amendment. We should not even be here talking about firearms. The days of firearms was 1967 to 1969. After 1969, we should have gotten rid of every firearm in Anguilla. Shouldn't have no firearms. The days, we should not be ever speaking about this, and I would hope that any young person that are listening to us speaking about this understand the consequences of those actions, Madam Speaker. Think about it. And the person sometimes say this to us, that we work so hard to promote Anguilla because we are a tourism destination, Madam Speaker. We work so hard to promote Anguilla, and then one or two persons undermine all of the work. And then when the knock-on impact is that we have less transients, less business coming to Anguilla, you're laid off because you can't get the hours. You are destroying the goose that laying the golden egg. This isn't about tourists. I heard somebody speak about tourists, tourists getting shot. But this isn't about tourists. This is about us, our brothers, our sisters, Madam Speaker. And in closing, Madam Speaker, I want to say this, Madam Speaker. Last night, I attended an event. And I met this lady when I attended this event, and I said, hey, how's your son? Her son was a great athlete. How's your son? She said, he's home. I said, where's he working? She said, nowhere. I said, how old is he now? She said, he's 20. I said, he's not working? I said, why he's not working? She said, because he's afraid to leave the house. And then she spoke of another friend of his who gave up his job and also became, for all intents and purposes, a shut-in. And Madam Speaker, I've been to Island Harbor, and I've spoken to persons in Island Harbor about becoming gainfully employed. And you know what they said? When a project comes to the eastern side of the island, then they'll go and look for a job, but they don't want to work in West End. And somebody spoke of fear. I think it was the Honorable Kyle Hodge who spoke about fear. Do you think that somebody in an island that is 3 miles wide by 16 miles long, that is living in Island Harbor, or living in West End, or living in Shoal Bay, or living in the forest, should be afraid to go from east to west, to work, to play, to frolic? Madam Speaker, it should never be, and we should never be here. And some people would like to blame political leaders. This has got nothing to do with political leaders, and I saw the honorable member for Valinart defending that position recently, Madam Speaker, when somebody said that when a political leader is that on? Yes, sorry, thank you. When a political leader is harmed, then politicians will wake up. But this has nothing to do with political leadership. Leadership starts in the house. There was a time, Madam Speaker, when we didn't have no political leadership in Anguilla. Prior to 1976, and I want to go back further, prior to 1967, who was the Chief Minister of Anguilla? The Chief Minister of Anguilla from 1953 to 1967 was Robert Llewellyn Bradshaw. His office was in the Secretariat in the Valley. His office was in Bastia and St. Kitts. There were 6 police officers on horses in Anguilla, Madam Speaker. So, really and truly, Anguilla was a country without governance and without governing. And we didn't have that. So it has nothing to do with political leadership. It has to do with personal responsibility for your own homes, your households, Madam Speaker. Each one of us have that responsibility, Madam Speaker, to train up a child in the way it should go so that when it is big, it will not depart from it, Madam Speaker. That is our responsibility, our sole responsibility. Now, Madam Speaker, the truth is that we may do so, and that child may become wayward. But most times, that child can also become the prodigal son who left the house after eating the fattened calf. And still when they come back, we put the fattened calf and we feed, create a feast for that son who made that bad decision and went out and frolic and had a good time, Madam Speaker. So, Madam Speaker, again, as I close, I am happy that we have bipartisan support for this particular amendment, Madam Speaker. And I would hope that the last gun-related crime in Anguilla was the last gun-related crime in Anguilla. Thank you.
Thank you, Honorable Member. Are there any other contributions to this bill? The Honorable Member for Sandy Hill is recognized.
Thank you, Madam Speaker. Madam Speaker, I rise in relation to the Firearms Amendment Act, but as I would have mentioned previously, the Criminal Code. And in fact, the Bail Act, Madam Speaker. And the three bills which have come to the House today essentially go hand in hand. And the crux of the issue that we're dealing with today is the strengthening of our firearms legislation. Madam Speaker, you have heard the previous speakers in this House, and you have heard the various views coming. And I have to say that this is certainly one occasion where there is unity of purpose in this honorable House between the members of opposition and the members of government. The reality is, Madam Speaker, is that on this 35-square-mile island, there is no room for the type of gun and crime violence that we are seeing today. The member for Road South would have aptly spoken about the fact that we are all connected by some degree or the other. I have family in Island Harbor, East End, the Valley, Blowing Point, and South Hill. And so where is it that I think that as a young person, that any person in Anguilla can commit the type of gun violence that's being committed today and not impact one family member or the other? Madam Speaker, it is time that we seriously address the issues that are facing us today. And as was stated earlier, the situation that is happening now in Anguilla is not unique to Anguilla, but it is our issue that we have to deal with while we are here in this country and while we are legislators in this honorable House. I have previously openly given my support in relation to the passage of this Firearms Amendment Bill, the Bail Act Amendment, and the Criminal Amendment Act. And I know it was mentioned earlier with respect to certain challenges that have to be overcome. But at the same time, there is such a thing as the public interest. And there is a public interest that is at stake in this country today. And the only way in which we can address the public interest is if we take a wholesome approach to dealing with all of the issues that we have. The Firearms Amendment Act, the strengthening of these legislations cannot be done in isolation. It is part of a larger series of issues that need to be addressed. There was mention earlier in terms of the CCTV cameras, and I too support the implementation of CCTV cameras across Anguilla. That too cannot be looked at in isolation. We also have to look at the social structure as to, in terms of what is happening with our children. The reality is, Madam Speaker, is that we have parents who are working 2 and sometimes 3 jobs. And their children are raising themselves, or they are being raised by someone else who we would not want them to have influence, get influence from. And the question that we need to address is, why is it that our people have the need to work 2 and 3 jobs to make ends meet? I think it is a greater issue than simply saying they want to have more money in their hand. I think it's more of an issue as to need. And so when it is our parents are absent from the home, who fills in? The single island-wide member, Honorable Kyle Hodge, made mention of it takes a village to raise a child. And I wholeheartedly agree. And while we may not be able to go back to the days where any person in the community can reprimand your child, at the end of the day, there has to be collective responsibility by each member of us in society. So even if we see something that is wrong, it is not appropriate for us to walk away and say, well, that's not my problem. Because what is not your problem today will end up being your problem tomorrow. And what we see with a number of our young persons is that some of these persons who are committing these heinous crimes have family members, parents who work in the establishments that are impacted. When I say impacted, Madam Speaker, I mean if we say that our biggest industry is tourism, the tourism industry, and we have persons who are working in the hotels and they rely on those jobs to make ends meet, to put food on the table for their children and their families. And at the end of the day, that very job is at risk. It is a problem. But we seem to have a situation where our young persons do not have regard for their own lives, much less for the lives of other people. And we have to understand where we are and try to understand how we've gotten to where we are, to be able to move back from that. And so when you talk about the legislation, the strengthening of the legislation, talk about the CCTV cameras, you talk about the social aspect, these are the items that we need to be addressing to be able to understand and to stop what is taking place in this country. Now, unlike the United States, Anguilla does not have the constitutional right to bear arms engraved in our Constitution. And so when we see the types of weapons that are being used in our streets, even at funerals, many persons are saying, well, where are they coming from? Yes, that may be one aspect. But the more critical aspect is how do we address the use of those weapons here in our country? And one such measure is the strengthening of our act, our laws. And so the Firearms Amendment Act speaks about persons being convicted under certain sections. And so sections 10(3) to 6 is a person shall not buy, sell, acquire, or transfer a firearm or ammunition. Section 11, there are restrictions on delivery of firearms and ammunition. Section 20, unless authorized, a person shall not be in possession of a prohibited weapon. Section 21, there's a restriction on carrying of firearms and ammunition in public. Section 22, there's a special restriction on carrying of firearms and ammunition in public places. And Section 23, that you shall not discharge a firearm in public. And so, Madam Speaker, there are required minimum terms depending on the nature of the offense, depending on whether or not the person is charged with possession of a firearm, discharging of a firearm, etc. But what is important, Madam Speaker, and this is why the opposition was interested and wanted to ensure that there was sufficient consultation on this matter, is that the minimum sentences essentially state that in certain circumstances, an offender, depending on the nature of the firearm, could be liable to imprisonment. And so the objects and reasons says that the bill amends the Firearms Act to provide for the imposition of a minimum term of imprisonment for specified firearms offenses. For an offense relating to discharging of firearms, the minimum term of imprisonment will be imposed whether or not the person charged is a first-time offender. And in relation to persons who are under 18 years, minimum terms of imprisonment will not be imposed if the person is a first-time offender. And so, Madam Speaker, what we are looking at today is the fact that depending on the nature of the offense, we have persons that will be liable to mandatory imprisonment. It is important that the general public is aware that this legislation is about to come into effect. And at a previous press conference that was held jointly with the Honorable Premier and the Governor and the Commissioner of Police, I would have openly given my support for these pieces of legislation coming to the House, and I would have further suggested that one of the items that I had spoken with the Commissioner of Police about was the fact that there ought to be an amnesty period. And the reason why I felt that the amnesty, and I still feel that amnesty period is necessary, is because there may be persons caught up in a lifestyle that may want the opportunity to give up whatever firearms that they may have in their possession. And I think it's only fair and reasonable in our democratic society that while we increase mandatory imprisonment sentences, that we also provide an opportunity for persons who may want to give up without any liability on their part, turn in the guns, the firearms that they have in their possession without being held liable, without being charged, without being taken before the court. And I am happy to see that there will be some movement in relation to that shortly, Madam Speaker. I would have seen that there is a proposal for an amnesty of sorts to be implemented at some point in the future. And that's important, Madam Speaker, because once that amnesty period comes to an end, or even if it's extended for another period of time, if it's successful up to that period of time, then it's important that people understand that once that amnesty period comes to an end, and you are caught in possession of a firearm or having discharged a firearm, then those mandatory sentences that are here in this bill will come into effect. And so as the member for Road South would have said, that when people are calling and asking for leniency for the children, it's going to be very difficult because the leniency period after the imposition of this bill is that amnesty period. And so that is the time that if parents, because we all as parents have responsibilities as well, and if we know that our children are doing things that they're not supposed to do, what is our obligation? What is it that we're supposed to do? And so we have to reach out. We have to utilize the resources that are available to us, whether it's calling the police on your child, you may not want to. But at the end of the day, if it's something that's necessary for you to do, then you should. And my father had always said to me that, well, to all of us, it was 5 of us, and he always said that if anything ever happened to you and your backside goes to jail, I'm not coming for you. You're going to stay there. And of course, I'm cleaning up the language a bit because he would use much more colorful language in his, and I always remembered that, and that was from high school days. And I, in turn, have relayed that same message to my children as well. And the reason for that is because I want them to understand that while I love them, I support them, I will go the distance for them, at the end of the day, I'm not going to support them with their wrongdoing. And if you are wrong and you continue to move ahead with your behavior, then you have to pay for the consequences of your actions. It is not enough for us as parents to say, well, this is my child and I love my child, so you'll protect at all costs. We have to start taking the steps necessary to understand our obligation as parents, as persons in society. And, Madam Speaker, the issue in terms of family members, and you would see that, and it was mentioned earlier, that our young people today, some of our young people, are not able to go beyond the areas in which they live. Some cannot drive from east to west because of fear. Some are unable to attend functions which are not in their particular area because of fear. Why on 35 square miles should our people live like this? We are too small. We are interconnected. And it is time that we take a stand. And it is time that we take back our country. But we have to provide help. I would have said on the radio the other day that there are times when our children can be considered to be victims as well. I don't see our children as all criminals. I do not. There are times when our children are caught up in situations beyond their control. There are times when they are groomed into a certain position. And so what we have to do as a society is to understand the weaknesses that are inherent in our society. Understand that our children can be a victim and be drawn into the circumstances that they end up in and take measures to help. And so when I talk about the social infrastructure, it is more than just providing help to parents for parent training, etc. It is more than social development. It is more than probation. It is actually understanding that at the core of us in our homes, some of our parents need assistance. Some of our parents, some of our children need support. How do we do that? That is a challenge that we have to embark on, even after the passage of these bills. And Madam Speaker, I would like to say that as elected representatives, all of us here in this honorable House, certainly on the opposition side and on the government side, are elected by the people to represent the interests of the people. And so when we come to this honorable House to make presentations, to explain the concerns that may be present, and to highlight the issues that may impact us, our people as elected representatives, we do not do so lightly. The comments that are raised, the points that we make on our feet are not minute, they're not insubstantial, and they are not petty. They are based on the fact that we as elected representatives understand the issues that will impact our people. And so those of us who are elected in the House, all of us in this House, should understand how we got to where we are and where we are today. And so, Madam Speaker, in closing, I would like to say that I support, as I've stated in previous forum, I support the Firearms Amendment Act. I support the criminal code that has come before. I support the Bail Act. And I support any reasonable measure that this government will take and will continue to take to ensure the safety of our people, to ensure that our young people are looked at and considered not just as criminals. I'm not suggesting that this is how the government side sees. I'm saying that in many occasions, they're not simply criminals, some young persons, but they are also victims. And so we have to understand what is happening in our society. We have to talk to our young people. We have to take the battle on and move forward. And this isn't something that's now. This isn't this administration. This has been going on for a while. But we are where we are today, where urgent action is needed. And I support the government with their efforts. Thank you, Madam Speaker.
Thank you, Honorable Member. Are there any other contributions? The member for West End is recognized.
Thank you, Madam Speaker. Madam Speaker, the agenda to date has been mainly about crime. And it's always unfortunate when most of the day is taken up with crime, but it's a necessity as to how we deal with it. It is always easy to blame, pass the baton to someone else and say whether it's in the homes, whether it's in the school. But Madam Speaker, we're all responsible. I think all of us need to accept that we have a responsibility of putting our hands on our hearts or looking in the mirror and say, you know what, I think I've done my part. And if we haven't done that, we cannot cast blame on anyone else. I think it is very important too that we always look to see what can we do to help. The honorable member for Road South mentioned a number of programs that are available. So there's no excuse that youngsters have got nothing to do. But unfortunately, Madam Speaker, there's a number of youngsters that we're not getting through to. And these are the ones that if they can go into a graveyard and shoot up at someone, they can, in the middle of the day, someone who's at work, a young man at work, and execute him in front of others. It says we've got a serious problem. I often talk about challenges instead of problems, but I think whichever language you understand, we have to admit that there's a huge issue that affects all of us. And this whole idea about fear, it is natural, Madam Speaker. It is natural, but all of us know that if you don't do anything about it, the fear will continue to grow and grow. So I think for us as elected members and those in our society who understand that we have a role to play, if we say to the very small few number of persons who act in a manner that is hurting themselves, whether they realize it or not, and if they're hurting themselves, they care less about you or me. But the fact is, if I care about myself, I'll do what it takes in order to protect myself. And I don't mean getting a gun. I mean that with the laws that are in place, gives us and the policing the opportunity to follow the law. One of the issues I have with our people in Anguilla is that we're quick to accuse those policemen or policewomen from overseas of being corrupt, being this. The fact is, Madam Speaker, if that is a problem or a challenge for us, why don't we as Anguillians volunteer and police ourselves? So before you blame someone else or accuse someone else, ask yourself the question, am I doing enough? Madam Speaker, again, I will do what I can. I know the minister mentioned about the golf training down at Aurora, so I'm hoping by 3 o'clock we're out of here so I can go and at least put some time in with some of the youngsters there that I would look to mentor, and I think that's what all of us should do in some way, whatever it might be. It is adopting someone within your community, and you're going to say that doesn't have to be in your community, it could be someone from the other side of town. If you decide that you're going to do the best you can to help someone, and half the time you like to think it starts in your home, but it should not be limited to your home. We talk about parents and the blame on parents. My mother left when I was 1 year old. I did not physically see my mother until I was 15 years old. My father, James Hughes, prominent person in West End, but I did not have that father-son relationship. The truth is, Madam Speaker, I didn't need it, because at that point in time, as a community, and there's a lady who's now struggling with arthritis and rheumatism, my aunt, Dorothy Connor. She was like my mother and my father. My grandmother, again, she was someone, at the age of 12, she said to me, I wasn't rude, Madam Speaker. I was on the hard of hearing, because when I was playing cricket, and especially if I'm batting or due to bat next, I couldn't hear her calling me. But when I got home, I felt it. But Madam Speaker, she said something to me one day, and she said, I'm tired of beating you. If you're going to be a bad child, you're going to be a bad child, but I'm tired of beating you. And I think for anyone to say that to a child, it says that by me hitting you hurts me just as much as the child itself. But what we really need, and hitting is not gonna do much to some of these youngsters. We need to find a way to get through to them. We need to probably listen to them, listen a little bit closely to find out what their challenges are, what their concerns, their misconceptions. And if we can do that, Madam Speaker, all of us, not just those in authority, but every single person in Anguilla, even at school, look out for someone that's close to you that you think might need help. If you see there's signs where that child needs help, your colleague needs help, raise that red flag. And I think, Madam Speaker, if we do that, we'll be surprised to see how far we can reach our goals about bringing back Anguilla to what we once had. We've been exposed to a number of distractions out there. There were always distractions, but they were focused. Again, growing up, we had more focus on the persons around you and in your community. We need to find those things as well. Not saying we're going back to the old days. We're looking back to find what worked and see if we can implement it today, because we need that in order to go forward. I thank you for your time, Madam Speaker.
Thank you, Honorable Member. Are there any other contributions to this bill? If there are no other contributions, I invite the mover to respond, please.
Thank you very much, Madam Speaker. And permit me also to thank my colleagues in this honorable House for their contributions, some of which were wide and varied and profound. I sat quietly listening and I descended into thought about the contributions in relation to the objects of this legislative measure. And I gather that all members recognize that what this measure seeks to do, in part, the object of this legislative intervention, which can only partly be achieved by the measure we take today, requires a wider community effort. And certainly, as what my colleague, the member for Road North, indicated, it's not merely that we are responding in a knee-jerk fashion and we're simply importing something taken from abroad. In fact, relative to legislative measures, I am sure by now my colleagues on the government side understand how I operate. I do not favor just borrowing something, whether it is from the United Kingdom or elsewhere, and passing it here. Neither do I see that things English in terms of legislation must necessarily be replicated in Anguilla without any kind of appreciation for the local circumstances and the need for it, and certainly the constitutional context in which we operate. I, for one, have always been a gatekeeper in that regard. I'm sure before long, members would appreciate what that means. I want to also make a comment because I think that the most profound intervention that struck me was that just given by the honorable member for West End. because it hearkens to not just what we seek to do in relation to punishment for gun possession and gun violence, the discharge of firearms, and so on, which is a scourge. But it hearkens to what, as the leader of opposition say, elected members. It hearkens to what elected members are to do, principally as representatives of their people. Hearkens to leadership. Leadership. What you can do and you are prepared to do individually, not just by passing legislation and talk. Because leadership is not a title, it is not a position. There are qualities of action. Qualities of action. And even though you're elected to represent people here in this assembly, it's not merely to just talk. And so I hope my friends on the governing side will forgive me if I say the most profound, in my opinion, contribution, in my opinion, was what the honorable member said in relation to what an individual here as a representative can do in your own community. That is leadership. You're called to leadership. And I thank my friends and colleagues, certainly in relation to this measure in the Firearms Amendment Act, those of you who demonstrated leadership by empaneling a committee and engaging the public. But I would remind you of the words of the honorable member opposite. There are things of action which you can do personally in your own community that demonstrates that leadership, that you are going to tackle some aspect of the ill of the growing delinquency and violence that are plaguing us now. Because colleagues, you're not merely here to occupy time and space and await a pension. You're here to lead. And so, Madam Speaker, I wish to thank honorable members for their support for this measure, and I look forward to other initiatives where there would be eager support and participation in tackling this issue. That having been said, I beg to move that a bill shortly entitled Firearms Amendment Act 2023 be read, a second time.
It has been moved and seconded that a bill shortly entitled A Bill for Firearms Amendment Act 2023 be now read a second time. Those in favor? Aye. Those against? The ayes have it. I call upon the clerk to read the bill a second time.
An act to amend the Firearms Act to provide for the imposition of a minimum term for specified firearms offenses.
Under Rule 45 of the House of Assembly, Rules of Procedure 2021, the bill now stands referred to a committee of the whole Assembly to be considered clause by clause. Assembly in committee.
Clause 1.
I put the question that Clause 1 do stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it.
Clause 2.
Madam Chair, there is a proposed amendment to Clause 2, and it is in Clause 2, in the insertion of 49A, by deleting the phrase 11 where it appears in subsection 4. That's on the overleaf.
Thank you. For the question that Clause 2 be amended to include the insertion of section 49A by deleting the phrase 11 where it appears in subsection 4, and do stand part of the bill. Those in favor say aye.
Aye.
Those against say no. The ayes have it.
Clause 3.
I put the question that clause 3 do stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
The title.
Madam Chair, I propose that the title be amended to alter 2023 to 2024.
Can you say?
Chair, I second.
Thank you. I put the question that the title be amended to read a bill for Firearms Amendment Act 2024 instead of 2023, and do stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it.
The enacting clause.
I put the question that the enacting clause do stand part of the bill. Those in favor? Aye. Those against? The ayes have it. The Assembly will now resume its sitting. You may report.
Thank you, Madam Speaker. I beg to report that the bill shortly entitled Firearms Amendment Act 2024 had gone through the committee stage with one amendment and is now ready for its third reading. Yes, two amendments. Two amendments. Now ready for its third reading. Thank you.
A bill for Firearms Amendment Act 2024, third reading.
Thank you once again, Madam Speaker. I beg to move that the bill entitled Firearms Amendment Act 2024 be read a third time and passed.
Madam Speaker, I second.
It has been moved and seconded that a bill shortly entitled A Bill for Firearms Amendment Act 2024 be now read a third time and passed. Those in favor? Aye. Those against? The ayes have it. I call upon the clerk to read the bill a third time.
An act to amend the Firearms Act to provide for the imposition of a minimum term for specified firearms offenses.
Bill read a third time and passed.
A bill for Property Tax Amendment Act 2024, first reading.
The member for Island Harbor is recognized.
Thank you, Madam Speaker. Madam Speaker, just want to say that we did have the Honorable Attorney General open the batting. He's negotiated well in the wicket, and certainly time for him to get a lunch break. I beg to move that a bill shortly entitled A Bill for Property Tax Amendment Act 2024 be read a first time.
Speaker, I rise to second.
It has been moved and seconded that a bill shortly entitled A Bill for Property Tax Amendment Act 2024 be read a first time. Those in favor? Aye. Those against? The ayes have it. I call upon the clerk to read the bill a first time.
An act to amend the Property Tax Act 2015, Act number 10 of 2015.
Bill read a first time.
Private members' bills, none. Private bills, none. Other orders of the day.
The AG opened the batting. Maybe he will, and he wants to go for lunch now. He has to wait because he's offering, I think, the Assembly a drink, so I heard, for his birthday. The member for Road North is recognized.
Thank you, Madam Speaker. Madam Speaker, if you'll just permit me, it'll be just brief, to pass on some condolences to some families that have lost loved ones over the last few weeks. First, I'll start by offering condolences to the family of Lizzie, the Gomes family in Natal. I'd just like to publicly express my condolences. And to the family of Franklin Connor, Frankie A.K. Baum, my former classmate